We date after 2 weeks.
Much obliged.
Item 1 for motion.
Among instructional instructions, it is issue citizenship certificate. The corporate issue confirm. May I please, Your Lordship? On last occasion, I had produced
Perhaps yes, Rocky.
citizenship certificate. এইটার মানে হিং অথরিটি বলতে কনফার্ম করে দিয়েছিলেন এটা কোন অথরিটি করছে নরমাল তো আছে এডিশনাল ডেপুটেশনাল
Lordship, 1 week time may be allowed, Lordship.
only but not one of the development.
Where is that document?
Not this.
Please pass it on.
Documents. Oh, yes.
কোন ইস্যু করেছিলেন?
It additional deputy commissioner ধরো না মানে citizenship certificate and actual B exhibit B আছে যে নয় ইয়াতে next expression of clarification page number 16 page number 16 migration to Diana.
Number 16.
Issue of the maybe is separated Hussein government.
You see, the only point here, you have the writ petition.
Yes, yes.
Come to page 50.
Thank you.
Third last paragraph, exhibit B.
Certificate of registration. It's under now. Claiming.
You see,
Yes,
here there are two flaws. You see the document,
Yes,
showing the original document.
yes, sir.
Showing the
Yes,
original.
yes. It is our.
Now, at the top, there is no name of the authority,
Yes,
but left side down below, you find a round seal,
Yes. All of us.
correct?
yes.
And against the signature also, there is a seal, correct? So if in 19, what you call, what is the year? 60?
67.
67.
Yes.
If some government officer did not put a seal in the top, can the document be rejected now?
No.
And secondly, here it says that it should be proved by primary evidence. Now, perhaps the tribunal is just confused what is primary, what is secondary.
Yes, okay. This is original.
The document is an original. other government receipts.
Yes.
For example, you go and pay a fine to the police for traffic offense. What you actually get is a carbon copy.
Yes.
Original goes to the treasury.
Yes. Yes.
When you deposit rent, the original goes to the first copy goes to the treasury. It's the second copy which is given to you.
Yes, sir.
Second and third copies, we have to return back the third copy to the court. So the family is confused as to what is primary evidence, what is secondary evidence. That was the only point.
Tax edition. Tax edition of 2 years. This 6. Lordship, 1 week time may be allowed, Lordship.
Both sides have presented. The pair made by Mr. G. Sharma, done at standing person for FT and border matters. This matter stands adjourned today. This on, give a date for a week. That is the only point involved.
Lordship. Lordship.
Item 2,
May I please your lordship? Lordship, the youngest counsel is suffering from some health issues. Lordship, humbly prayer for adjourn for the day, lordship.
Both sides are represented. Learned counsel, the hearing or the petitioner submits that the learned counsel holding the brief is suffering from some health issues. Therefore, the prayer for adjournment is made. Here is about. Matter stands adjourned today, list on a day after 2 weeks.
27 February.
Obliged, lordship.
Item 3,
The petition is filed against, my lord, interim order, my lord, passed by the Central Administrative Tribunal, whereby, my lord, the transfer order was, my lord, stayed by the London Central Administrative Tribunal, my lord, not without any justifiable reasons. My lord, on the last occasion when the matter was taken up, my lord, the Honorable Court.
We missed the point. Have you filed an application for vacating? No.
Yes, my lord, we have
Where is
filed
that?
the application of
Where is that?
vacating, and in that also, my lord, the court has not passed any order, and
Where is that?
my lord, page 131.
Lord, the entire matter will be heard by the learned Central Administrative Tribunal on 19/2, my lord, for final disposal.
On 19/2.
Yes, my
Where is the order?
Lordship.
Only difficulty is that, my lord, the employee, after getting the transfer order and after being relieved, they do not join the next place of posting, nor they join their current establishment. They are sitting, my lord, without taking any absence of leave, and thereafter they claim salary for that period.
You know how to deal with those issues.
Yes, my lord.
The department does know to deal
My
with
lord.
those issues.
My lord, will take it, will keep it pending. my lord.
You don't take steps against them. If because of the order they don't join, you take steps against them, you
No, lord.
131. No, where is your application? Where is your application
No.
for vacating? for which order 131 is passed.
Not the application, we have not annexed, my lord, we have.
You have a copy of it? Both sides, anybody has copy of that?
Mal.
49. No, sorry. Will not interfere when you have agreed to a date of 16 to 19/2. That's an agreed date.
My lord,
That's number one. Number two, at page 131, the in the paragraph 3, page 131,
no,
the applicant has not been formally and factually relieved. He has not relinquished the charge nor handed over the charge and not deposited his keys. Against this,
Page
against this observation, we don't find anything in your interrogatory application.
page 64, their own application, my lord, there is a relieving order. Page 64.
No,
Oh.
no.
He has a, you mean relief from the,
Mr.
my lord,
Gupta,
my lord.
this paragraph 3 of the order at page 131,
My lord.
in respect of these allegations, there's no statement in your interrogatory application. You have quoted the passage from a Supreme Court of India that the action of not reporting at the place of posting is deprecated. But you have not made an allegation.
He may not hand over charge, that is Malad the wrong action on his part. He
You did not take any steps. What prevented you from?
officially, Malad paid 64,
What
he has been
prevented-
relieved.
What prevented you from drawing up a proceeding against him? If he does not hand over the keys of the section, why you are sitting idle?
No.
You don't do it. You don't put him to notice that if you don't join, your salary would be deducted. And then you agree to a date of hearing, 19/2. Keep it pending till 19/2.
No,
If
no.
it doesn't happen, then
No,
take it up.
No.
But Mr. Achimukar and at CGC also heard. Mr. S. Chaudhary, Leonard Counsel for the respondent. Next paragraph. The learned CGC has submitted that as per instructions received by him, the respondent is neither attending his duties. He has submitted that the petitioner has been relieved from his post as Deputy Chief Mechanical Engineer, construction, NF Railway. Page number
64, Malad.
for which reliance is placed on the office order number 68/2025 within bracket GAZ. Bracket closed. Dated 21/10/2025. To show that the petitioner was released from his place of posting.
To East Central Railway, Malad. Last line of first paragraph. Page 64. He is released from NFL construction organization to carry out his.
You write, your English is very good. It's a beautiful English. Some awards for writing good English can be given. You write before relinquishing the charge.
Yes.
So your order itself is qualified. You pass an order of relieving him, but say before relieving, you give this.
If he doesn't give, my lord, willfully, again, my lord,
Then
that is.
we can't advise you what to do.
That is.
Stop. Next paragraph. However, the court notices that in the same order, it has been provided that before relinquishing the charge, the petitioner should deposit the metal pass or my penny to the gazetted section of the headquarters. Full stop. In this regard, the court further takes notice of the contents of the order dated
28/10/20.
11/11/2025, passed in MA 210 of the 2025, wherein a privacy satisfaction is recorded that the respondent has not relinquished charge, not handed over the charge, or deposited keys to the gazetted section. Stop. The learned Central Administrative Tribunal from Gauhati has also recorded that the respondent has not reported for duty after 22/10/2025. Stop. Next one. Be that as it may, the learned counsel for the respondent has produced a copy of order dated 6/1/2026, passed by the learned Central Administrative Tribunal, Gauhati, wherein it has been recorded that it is agreed to by both the parties, the matter be listed for hearing on 19/2/2026. Until then, the interim order was ordered to continue. Next one. In view of the agreement between the parties for fixing a date of hearing on 19/2/2026, the court is inclined to record its hope that on 19/2/2026, the learned Central Administrative Tribunal, Gauhati, shall make all endeavor to hear and dispose of the matter. Next one. Accordingly, these petitions kept pending, awaiting for the orders that may be passed by the learned Central Administrative Tribunal, Gauhati, on 19/2/2026. Next para. List the matter on 25/2/2026.
My lord.
We are returning you this.
My lord.
My lord, in this case, I am appearing as a legal aid counsel,
In,
item number 3, Miller.
but Mr. Chaudhary you have been engaged.
Yes, my lord, he is personally giving me wakalatnama, my lord. That is.
Okay, we record your presence also. Okay, just record. At the first paragraph, no? After the first paragraph. Mr. B.K. Sen, learned legal aid counsel also appears for respond number 1. However, as the respondent has engaged his learned private counsel by giving wakalatnama. You have filed your wakalatnama?
Yes, my lord.
Which has been filed, we exempt further appearance of the learned legal aid counsel on behalf of respond number 1. Accordingly, the registry shall not reflect the name of legal aid counsel on behalf of respondent number 1 and reflect the name of Mr. Chaudhary as learned counsel for respondent number 1 by listing the matter next. But take note, even if your name doesn't come, please,
But I'm not going to appear.
we relieved you.
Yes.
No, not you, no, Mr. Chaudhary.
Yes.
Even if his name is not shown, he will appear.
If my learned friend is there, but already. I am obliged to them. Hello.
Item 4 for motion.
Met legal lodge. Well, in this case, my lord, record was called for, but order dated 7/1/2026, my lord. Yes, 45. Imperial order, your lordship will find at page 45, my lord.
No, we have not called for the records. We have not called for the record.
Notice was issued, my lord,
Yes, it was not, this was also not issued. We wanted to examine what is,
that the bail payer will be considered after receipt of the LCR, my lord. In that order, my lord, there is a point raised by maintainability that some delay part was there, my lord.
yes, yes.
Yes, that I have explained, my lord. Paragraph 5 at page 7, my lord. What happened, my lord? Earlier, he was taken into custody. Thereafter, was released from this central jail, Tezpur, my lord. That your lordship will find at page 50. He was thereafter released, my lord. The petitioner was under impression that, my lord, his case has been ended up, my lord. Therefore, he did not take any steps to silence that, my lord, the order of the learned finance tribunal, my lord.
It can't be a good ground.
That is, may not be a good ground, my lord. That is my lord, other. My submission before your lordship, my lord, your lordship will kindly be pleased to, my lord, consider and condone the delay part, my lord. Then matter will be hard on the merit, my lord.
Your exhibited documents.
Yes, my lord. What about, my lord, the exhibit 1, my lord, this
NRC voter detail.
NRC, my lord,
Then exhibit 2 is also NRC detail. 3 and 4 are voter ID card.
voter ID card, my lord,
5 and 6 are also acknowledgement of receipt of NRC.
my lord.
And 7 is a certificate.
Certificate issued by the
What is-
Gauhati, my lord.
What is the other document you have?
Other document, with regards to the, my lord, exhibit 1, my lord, the learned tribunal come to a conclusion that, my lord, it is not admissible.
Correct.
My lord, it is, however, my lord, if your lordship sees the exhibit 1, my lord, the learned member himself put his signature, my lord, by admitting it, my lord. It was exhibited, my lord, he has duly signed, my lord. Kindly page 15, my lord.
So, are you proposing that the law is that even if an inadmissible document is produced, the presiding officer will not sign it?
My lord, it is, my lord, my understanding is then, my lord, when I suppose, my lord, file an exhibit, my lord, it is, my lord, proof in original, my lord. The learned tribunal has put his signature in the exhibit column that it is exhibited, my lord.
Let us say,
My lord.
you see, first we'll understand the legal proposition.
my lord.
Number one, is it your argument that once the document is inadmissible in evidence?
No, my, that
presiding
is not
officer
my
doesn't
argument.
Sign it.
That is not my argument, my argument. This is about, this is NRC copy, my lord. That has been, my lord, I have obtained from the office, my lord. Thereby
page?
it was exhibited, my lord.
Which page?
Page lordship will find at page 15, my lord.
15.
15, 1-5, my lord.
Do you have a copy of Evidence Act with you?
I'm sorry, my lord. Line tribunal said that, my lord, 65B certificate was not there. Notwithstanding anything contained in this act, any information contained in an electronic record, which is printed on a paper, stored, recorded, or copied in optical or magnetic media, produced by a computer, hereinafter referred to as a computer output.
Just wait here.
My lord.
Come to page 15, 1-5.
My lord?
Come to page 15 of your writ petition.
15, yes, my lord. Yes, my lord.
This is the document, NRC,
Yes, my lord.
correct?
Yes, my lord.
Now you read the rest part of it.
Yes, yes, my lord. I got it. Lordship, my lord. Shall be deemed to be also a document if the conditions mentioned in this section are satisfied in relation to the information and computer in question and said.
You can omit for the time being.
My
Please
lord.
stop here. Now, you see, unless there is a certificate, this is not even a document.
My lord.
It says deemed to be a document,
My lord.
correct?
Deemed to be a document.
Deemed to be a document doesn't mean that it is a document.
My lord.
As a, you see, I give you an example. I give you a very rubbish statement that now it is night.
My lord.
Now you want a positive order from the court and therefore you say, yes, lordship, it's night. So it's not it's a daytime.
My
You are
lord.
deeming it just to please us.
My lord.
You admit it to be a night. So that deeming part does not create a document. Correct. Now come to that page 15.
My lord.
15 is the last two lines, image ID.
Image
This is
ID.
an image.
My lord.
So any image printed, you just now read. referred to as, produced by a computer, referred to as a computer output. This is a deemed document.
Deemed document, my lord.
And next line is
And
generated by,
and shall be admissible in any proceedings without further proof or production of the original as evidence of any contents of the original or of any fact stated therein on which direct evidence would be admissible. Madam, my humble understanding is that, my lord, if we, my lord, exhibit certain documents, computer generated documents, my lord, before, my lord, this new evidence come, my lord,
there is a series of judgment, not even by the, not only by the Supreme Court, High Court also, dealing with the electronic record.
my lord. But, my lord, my lord, this petitioner, my lord, while exhibiting this document, my lord, he never considered this as a electronic document, my lord. He exhibited this document, my lord. He's, my lord, on a bona fide belief that this is an original document, my lord. If your lordship gives me some opportunity to, my lord, prove as per the Indian Evidence Act, my lord, there'll be, my lord, will be, my lord.
This page 15 is of which year? It's a.
2015, my lord, downloaded, my lord.
No. But this belongs to which year?
1951, my lord.
1951.
My lord.
In 1951, this NRC is made under which act? You forgot it, you will not find it there.
My lord.
It is under the Census Act,
My lord.
1951.
My lord.
So under Census Act, it's inadmissible in evidence. It is, there's an exclusion clause in the Census Act,
My lord.
which prevents this to become a evidence.
My lord.
Census Act. Census Act.
Thank you. Sir.
This is section 15.
My lord.
Please read that. You'll refresh our own memory.
No person shall have a right to inspect any book, register or record made by a census officer in the discharge of his duty as such, or any schedule delivered under section 10, and notwithstanding anything to the contrary to the Indian Evidence Act 1872, no entry in any such book, register, record, or schedule shall be admissible as evidence in any civil proceeding whatsoever, or in any criminal proceeding other than a prosecution under this act, or any other law for any act or omission which constitutes an offense under this act.
We can't help you.
Rather, my lord, it would create problem, my lord. This last line, my
We
lord.
don't know.
My lord. But
Begins, Yes.
Mr. Bumble.
Payment for transference. Speed. It means that there is minimum value. For the volume of the policy says that this how is the max? It will be possible for that to be valuable to our also. It is how is the max? Why is the max?
My lord. That must be followed, my lord. At this stage, my lord, may I pray, my lord, this, my lord, my repetition may be accepted. My lord. My lord. That is, my lord, total ignorance, my lord, of this petition, my lord. That part I admitted, my lord. But, my lord, from edge of justice, my lord, and a statement made in the paragraph 5, my lord, the delay part may be condoned, my lord, at this stage, my lord.
As Lordship has already pointed out, and same thing has been quoted in Abdul Majid case, Lordship. WPC 6090 of 2016. 6090 of 2016, Lordship. And where Lordship in para 11, Lordship, it was stated Abdul Majid MA JID versus Union of India. Yes, Lordship, Lordship para 11, WPC 6090 of 2016. Same thing has been quoted, Lordship, in para 11, Lordship. Decided on 15/3/2018. Para 11, Lordship, where it has been stated that, Lordship, NRC 1951 was prepared on the basis of Census Act 1948. As per section 15 of the Census Act 1948, record of census are not open to inspection and thus not admissible in evidence. Therefore, in Bhanwasa Sheikh versus Union of India 1970, Assam LR 206, a single bench of this court categorically held that NRC extracts produced to prove domicile in India is not admissible in evidence for any purpose. We are in complete agreement with the view expressed by the learned single judge in Bhanwasa 6. Therefore, Exhibit 1, that is NRC document, is no evidence in the eye of law. And secondly, Lordship, in Rafiqul Haq's case, Lordship, 2025 SCC online SC 1160. Rafiqul Haq, ROFIQUL HOQUE. 2025 SCC online SC 1160. SCC online SC 1160. And paragraph, Lordship, 28, Lordship, after discussing all the things, Lordship, what come to the conclusion that, Lordship, for the reasons detailed above, the inclusion of the name of the appellant in draft NRC would have no bearing on the order passed by the tribunal, affirmed by the High Court, declaring the appellant a foreigner, Lordship. So same thing has been settled by the Supreme Court also. And regarding delay and laches part, Lordship, there is no sufficient ground, no satisfactory explanation is there in the paragraph 5, Lordship. And Lordship, this issue was also discussed, Lordship, in several occasions, in several repetition, Lordship. One is Abdul Majid, Lordship. Majid Ali, WBC 2930 2025. MAZID Majid Ali, MD Majid Ali. And Lordship in writ petition number 2930/2025. Yes, Lordship. In para decided on Lordship 16/7/2025. Para 12, Lordship. Para 12, I am reading, Lordship. Under the circumstances, it is found that petitioner was granted adjournments more than what is prescribed under paragraph 314 of the Foreigners Tribunal Order 1964. Moreover, the petitioner has invoked the extraordinary jurisdiction of this court under Article 226 of the Constitution of India after a lapse of about 6 years and 5 months, and the delay and laches on the part of the petitioner is not satisfactorily pleaded or explained. Under such circumstances, the principal delay defeats equity as referred to in the case of Mrinmoy Meiti Supra is found to be squarely applicable in this case. The petitioner is found to have accepted the impugned opinion for more than 6 years. Therefore, the unexplained delay and laches assailing the impugned opinion dated so and so by filing this writ petition on 25/2025. This entitles the petitioner to a relief.
কপি আছে নেকি সেইটো কপি আছে নেকি মই আপোনাক হোৱাটছআপত দিম মই মোক দেখা কৰিব লাগিব
And similar judgment is another judgment is there, Lordship, on same footing, Lordship. 3975 of 2025. The FUJERA Fujera Khatun alias Johura Khatun, JHURA Johura Khatun, KHATWN, WPC 3975 of 2025. Decided on 4/8/2025. T975 of 2025. Paragraph, Lordship. Eleven, Lordship. 11. And Lordship. And
this judgment of
paragraph 18 also, Lordship.
judgment your lordships my lord, in WPC 2930, that is the my lord, facts are not similar, my lord. This is in this case, my lord, these certified copy were obtained, my lord. That was he was sitting idle, my lord. In my case, my lord, I was in jail, my lord, and thereafter I have been released, my lord.
So
I was in impression that, my lord, my case has been ended up, my lord. Please, lordships, my lord, this delay part, my lord, it is complete discretion, your lordships, my lord. In this case, my lord, lordship may, my lord, exercises this your lordship's discretion, my lord, because facts are different, my lord. Again, recustody, my lord. First custody, my lord, 23/3/2020. 23/03/2020, my lord. 23/03/2020. Yes, my lord. Release on, my lord, 24/3/2022. That is, lordship will find page 50, my lord. Again, my lord, 25/5/2025.
During COVID period, Lordship, he was released, Lordship.
After arrest, my lord, immediately, we are before your lordship, my lord. PK Bhuya. I'm deeply obliged.
Item 5.
May I please your lordship? Some records are missing in,
Lordship, here also I am praying for 1 week time, Lordship. Yes, Lordship. I have already informed the tribunal, Lordship. So within a week, I shall get it, Lordship. And another problem is there, Lordship, there is UD post is vacant, lying vacant, Lordship, there. So, Lordship, the tribunal is facing some problem due to lack of a UD, Lordship. Yes. Affidavit. Yes, Lordship. 95 years.
95. So we'll have to direct him not to be arrested. Even though there's no prayer in the writ petition. Considering the age 95 and with the inability of the established to locate the records. We are holding reliefs. We're granting bail even with there's no prayer.
no prayer, your lordship, because there's no record, your lordship, for that reason, your lordship.
But you have not made the prayer.
Lordship, lordship,
Problem is that
lordship,
every
95,
time we can't hold reliefs.
lordship.
for this G. Boral and counsel for the petitioner and so for the respondent. Next paragraph. The learned standing counsel for the FT and border matters has submitted that though that he is written to the learned member, Ordinance Tribunal number 2, Nagaon, to trace out and or reconstruct the records of FT case number 34 of 2009, arising out of SP reference case number 302 of 2005. But the records could not be traced out. So it is submitted that at present the post of superintendent of the said learned tribunal is vacant, and therefore there is some difficulty on part of the learned presiding the learned member that trace out the records. Next paragraph. As the reasons assigned for not being able to get the information about the records has to be accepted in the absence of appointment of a superintendent of the Ordinance Tribunal number 2, Nagaon. Next paragraph. How, in this writ petition, it is projected that the petitioner, namely so-and-so, alias so-and-so, whose age is 95 years, desires to assail the opinion passed against him in the said FT case number 34 of 2009. However, as he has not been able to collect the certified copies of the records, the petitioner has not been able to challenge the said opinion. Next paragraph. Accordingly, as though there is no prayer for bail made in this petition, but considering the age of the petitioner projected to be 95 years in the affidavit filed in support of the writ petition, considering the said age of the petitioner, the court is inclined to grant bail to the petitioner, namely so-and-so, alias so-and-so. You look this 5,000, this 5,000 in the subsection of the Superintendent of Police Border Nagaon. As one of the conditions said that the petitioner shall not leave the territory of district of Nagaon without informing the officer of the Superintendent of Police Nagaon in writing and providing the place he intends to visit. Next. The continuance of bail should be subject to further orders that will be passed in this petition. Next one. Court is inclined to request the Home and Political within bracket B, Secretary Department. Take immediate steps to fill up the post of superintendent of the Foreigners Tribunal number 2, Nagaon, if not already appointed by now. It should be done in a specified time period. Next, by the United Standing Council for the FT matter and border matters shall transmit a downloaded copy of the order to the Secretary to the Government of Assam, Home and Political within bracket B department. Bring the order to the notice of receipt of property. List. How much time?
Lordship. I think Lordship within a week I shall get it, Lordship.
Within a week. We fix it on 6th of March.
Lordship.
6th.
Bishop Lysbeth.
But don't engage your presiding officer to find out records. Correct.
Lordship.
Item 6.
This is a contempt application, my lord. The order is at page 18.
Yes, Mr. Wayne. Mr. Sharma?
Yes, my lord, page 18, division bench order, my lord, writ appeal order. And operative
Page?
part,
Page.
page 18, writ appeal 151 of 2025. The learned singles bench order is at page 10 to 17. And honorable court directed the district scrutiny committee to place the case of the petitioner before the committee within a period of 8 weeks. And I have submitted the representation, page 24.
In 8 weeks. It's not been done. Have
Nothing
you
has been done.
communicated this order to the authorities?
Nothing has been done, my lord. I have approached the authorities.
Where is that?
My lord, page, paragraph, my lord, representation page 24 and 25. This is the translated copy, and 25 is vernacular copy.
Mr. N. Sharma, then counsel the petitioner. Next, by filing this contempt petition under section 11 and 12 of the Contempt of Courts Act, read with article 215 of the Constitution of India. The petitioner alleges willful disobedience and non-compliance of the order dated 15/9/2025 passed by the division bench of this court, WA number 151 of 2025. Wherein a specific direction has been given to the in case of the appellant, as of the petitioner, was limited to the district scrutiny committee, Dhemaji. Page 23. Huh? Next paragraph. It is submitted that representation along with the certified copy of the order was duly submitted before the office of the district commissioner, Shamaji, but till date, petitioner has not been informed about decision, if any, by the district scrutiny committee. Next one. Issue notice returnable on due date after 4 weeks. The petitioner shall take steps in course of the day for service of notice and the respondents by speed post with AD of the learned counsel. The petitioner is permitted to collect the postal receipt number from the registry and submit postal track report prior to the next date of listing. Next. The next paragraph, the pendency of this contempt petition shall not be a bar for the respondents to show compliance of the order dated 15/9/2025 passed by the court in WA 151 of 2025. Next paragraph, list on swings. Steps in course of the
Yes.
day.
If any order is filed, that may be communicated, my lord, during pendency.
That we don't require to tell you, tell them,
Yes.
you do it.
Item 7 for motion.
So in this case, we have filed the additional affidavit as per earlier order. So that is not on record, Lordship. Lordship may call for and fix it on some other day. Lordship. On 13, we have filed it.
Is you the third and then counsel for the petitioner submitted that on 13.
Yes.
2.
13.
13/2.
Yes, Lordship. 13 to
2026, and
addition.
additional affidavit has been filed by the petitioner. But the same is not on record. Next, the registry shall tag this affidavit of record. Next, list on Saturday, Friday, sorry.
Right.
Friday would be 22. No, sorry, 22/0.
22.
2/0/2026.
I would like Lordship.
Wait for the record. This is the-
This February. Item 8.
May I please your option, my lord? So by filing this writ petition, my lord, I have come against the ex parte judgment, party opinion. And my whole contention is that, my lord, I did not receive any notice. I specifically made in para 2 of my writ petition. On the other hand, the advocate who appeared before the tribunal, my lord, he filed in Bhokalatnama. I made a specific statement that Bhokalatnama was not even signed, or, my lord, no any thumb impression was even put by me. Therefore, absolutely it is an ex parte decree. That apart, on merit point of view also, my lord, I am in a position to establish my linkage by producing all relevant total list. And I have prepared a genealogy, my lord. Of course, it is not in the part of the record. Original, my great grandfather is Ahmed Ali. He is having a Shahad Ali. He is having, my lord, 4 different children. And I am, my lord, my father was Ahmed Ali, he is the son of Shahad Ali. And Munsher Ali, my father, is the, my lord, son of Ahmed Ali. And Munsher Ali is my father. Munsher Ali is having number of children, and Sharifa is one of the daughter. And I married one, my lord, Amjad Ali. Notice was served to, my lord, Ajmat Ali. And at that point of time, I made a statement. Notice was served to village, my lord, Foliamari Hub. But I made a statement that in 2002, I left the matrimonial house and started living with my parents in the paternal house at a different village. Therefore, my lord, Lordship will examine this question, my lord, whether the Bhokalatnama was filed by me, and application which was filed by the advocate, my lord, is also an advocate engaged by me. I have also, my lord, obtained the certified copy of the Bhokalatnama. This is, of course, not a part of the record. Bhokalatnama apparently shows that it was not even signed by me, and that was the findings of the tribunal disseminate. Tribunal also recorded at page 37. Relevant part is 38. 1, 2, 3, 4, 5, 6, 7, 8. 9th line from top. Bhokalatnama was not signed by OP. One, my lord. Oh, Bhokalatnama, my lord. Certificate copy, my lord. I have got the photocopy of the certificate copy, and certificate copy is with Mr. Jashim. original to दिया
Yes, sir.
original सा क्या होता है original सा क्या होता है हाँ
Lordship, page 36 is the process server report, Lordship. Yes, Lordship. মাননীয় মহোদয় অধীনৰ বিনীত নিবেদন এই যে শৰীফা ৱাইফ অফ আমজাদ আলী ভিলেজ ফলিহামাৰী PS মায়ং ডিষ্ট্ৰিক্ট মৰিগাঁও আছাম উক্ত চমনৰ শ্ৰীমতী শৰীফাৰ তদন্ত কৰিবৰ কাৰণে উক্ত গাঁৱৰ চৰকাৰী গাঁওবুঢ়া মহম্মদ চাইৰুল ইছলামৰ লগত গৈ মহিলাগৰাকীক পাই তেওঁ চহী কৰিব নজনাত তেওঁ সোঁহাতৰ বুঢ়া আঙুলিৰ টিপ চহী লৈ গাঁওবুঢ়াক সন্মুখত চমন দিয়া হয় আৰু চমন জাৰি কৰি মহামান্য আদালতলৈ গৈ চমন প্ৰেৰণ কৰা হ'ল। So Lordship, a notice has been duly served, Lordship. Everything has been matching, Lordship. Husband names has been matching now, Lordship. Present petitioner creating a story like that, Lordship. So Lordship, I think Lordship notice has been duly served and proceedings never bothered about this case, Lordship. After a gap of Lordship, 15 years, Lordship, more than 15 years. Now she approaching before this honorable court. And Lordship, my humble submission is that Lordship, there is no infirmity in the opinion passed by the learned tribunal, Lordship. And your report is just page 29B, Lordship.
My lord, my lord. My lord, only my lord photocopy may be given. Photocopy to go. My lord, my lord. My lord, only my lord to reply his submission, I say that my lord, page 36. Husband name is not my lord. His husband is a different name, Azmat Ali. My husband is Amjad Ali. Azmat Ali at page 33. Azmat Ali. My husband is Amjad Ali. And village is Foliamari. At that point of time, I am residing in Shandai Khete village. And the Gauhati, my lord, who accompanied the process server, Gauhati was not examined. At least to ascertain whether notice was duly served or really served on the proceedings. And he is the best witness. Nineteen 66, then my lord 1970, 75.
Your own voter list.
For my voter 97.
Where is that? Which page?
My lord, I'm showing you. এখানে সুন্দর 75, 75. Date to given. Voter list to given.
97.
97.
Is it page 49?
I'm-
50, page 50?
Yes.
And there is no name.
No, no.
In page 52, 2017 voter list lordship.
50 is 97.
97.
You don't find your name, that's why we
Yes.
asked.
I'm showing you.
Next page lordship, 52 page.
Voter list.
52, 2017.
Here again husband name is changing lordship. Wife of Mansoor Ali.
Mosur is the father. 9.
Vernacular has page 54 lordships.
We have seen that.
লিখে যাওয়া তো না
Special voter.
Nineteen ninety. এটা কি?
97,
1997,
1997.
হুম। কোনটা?
Certified copy.
My lord. My lord. Well, I also don't. Petition was, my lords, I don't want to, my lord, shift my burden, my lord, to anybody. Because I will have to burden, shoulder the burden, my lord. That was. My lord. I'm sorry, my lord. But in support of my case, my lord, is an ex parte judgment. And also, my lord, question is raised barred by limitation, huge delay. Same judgment is delivered by our High Court, report in 2021-6 GLR 667. Court has taken into consideration the whole concept of justice.
Please pass it on.
I'm sorry, my lord.
It's okay.
নামটা আছে তোমার? মুক্তিরানী পাল। কোটেশ্বর সিং আৰু বাইদেউ। And my lord is one of the, my lord, member of the division bench.
Oh, my lord.
We'll take a look at it.
Oh, okay.
You collect your copy from the, what do you call, the certified copy tomorrow morning.
My lord, in item number 5, lordship.
Ah.
Person concerned has already.
Died, your lordship. Just when I just informed the case to the son, your lordship, petitioner, they informed that before 1 month ago, he died, your lordship.
Still, the record will be required.
Yes, lordship. I filed impede petition, your lordship. In the meantime, your lordship, if record.
That can do, lordship.
Take a fresh order. Item 5, I have to cancel. Cancel the earlier. Item 5. But Ms. G. Baral and talks for the petitioner. Stop upon instructions. She has submitted that the son of the petitioner has informed that the petitioner, namely Matlab Ali alias Matlab Ali, has died about a month ago. However, she does not have the document to that effect.
Substitute.
Next para. The Mr. G. Sharma, Lanet, standing counsel for the FT and border matters, raised for some more time to obtain information regarding the records of the case of the petitioner from the foreigners tribunal number 2, Nagaon. It is submitted that the said tribunal is currently functioning without a superintendent, for which there is some delay in collecting in tracing out the records. Next one. In view of the statement that the foreigners tribunal number 2, Nagaon is functioning without superintendent, court deems it appropriate to transmit a copy of this order to the secretary to the government of Assam, Home and Political within bracket B, bracket close department, so as to enable them to examine and make an attempt to fill up the vacant post of superintendent of the said learned tribunal in a time-bound manner. Next, we request the learned standing counsel for the FT and border matters to transmit a document copy of this order to the secretary to the government of Assam, Home and Political within bracket B, bracket close department. Bring the order to the office of the said authority. Next, this term, 6/3/2026.
Much obliged.
Item 9.
Lord. In this case, lordship, I have to file an IA, lordship, for some correction, lordship,
Correction
in the cost title.
on the both sides are represented. On the fair laid down, Mrs. B. Bush. Matter stands adjourned, so anyone have to file, we need to look at the application.
Respondent number 7, lordship.
Correction of cost title in respect of respondent number 7. Matter stands adjourned, list as and when the interrogative application is filed.
Lordship, I'll file it within this week only.
Whenever you do,
Yes,
you file it, will come.
yes,
Just
lordship.
tell the section, they will tag it.
Deputed. Lordship, I'm there as a legal aid counsel.
Legal aid counsel. Done a legal aid counsel.
Dep-
Yes, item 11.
I'm grateful for your lordship by allowing me to appear online, my lords.
Yes.
The impugned order is at page 24.
Mr. D.K. Agarwal and counsel for the petitioner and also for the respondents. Filing this petition under Article 226 of the Constitution of India of the petitioner has received the opinion dated 1/11/2022, page 24. Passed by so and so in case number so and so, reference number so and so. Thereby declaring the petitioner to be a foreigner of 4/25/1971. Next, the inordinate delay in selling the impugned opinion, keeping the issue of maintainability open from issue notice returnable on so and so. Extra copies within 2 days. All for the records, the consent tribunal and following email address. Next, prayer for date shall be considered on receipt of the tribunal's reports. Next para, in the meantime, if the petitioner in the proceeding. 10 years up. Spelling, huh? Yes, and said is apprehended, he shall not be deported out of the country without order of the court. Next, however, the petitioner shall cause production of a certified copy of the order before the superintendent of police border. Which place?
Page 24.
Dhubri.
No, border.
Dhubri.
Next para response. Have a date.
Much obliged. your lordship.
18 published.
Item 12.
May I please your lordship?
Yes.
The impugned order dated lordship, 12/12/2016 lordship, so,
Page?
page lordship. Page 32 lordship.
22.
Lordship.
32.
So, 12,
No.
No. 12.
I'm sorry, lordship, my item is 13 lordship.
Item 12.
He was sitting here.
None appears in court for the petitioner. How all the respondents are represented by filing this petition. Opinions at page 112 dated 31/10/2025. Passed by so and so in case number so and so, reference number so and so. Thereby declaring the petitioner to be a foreigner of 25/1971 stream. Notice steps will include this, call for the records. Considering the projection made in this rectification. 10 days. Granted, to the petitioner to take bail of rupees 5,000 to be satisfaction of defend of police order. Valpara. No, List of sales. List after 4 weeks. Make it in 4 weeks.
Item 13.
Yes.
Lordship, the type copy of the impugn order, Lordship, page number 32, Lordship. Dated is 12/12/2016, Lordship, ex-parte order, Lordship. So at this stage, Lordship, we want to only call the record, Lordship.
You have annexed the copies of the order sheet.
Lordship, we annex the order sheet, but Lordship, in this matter, what happened, Lordship, the petitioner is a illiterate person, but somehow he just received this copy, and we also annex another documents, Lordship, to additional affidavit. So, Lordship.
But in this writ petition, you have not shown any good reason for us to even issue a notice or call for the records.
Then, Lordship, we may be allowed to file the additional affidavit to another documents, Lordship, because we are not annex more documents, Lordship.
No, documents you forget. But how do you explain the delay?
Lordship, we
We are not on the documents, we are on the explanation of delay.
Lordship, we annex a judgment, Lordship, which is page number 38 regarding the delay, Lordship.
No, we'll tell you what has happened. Mr. Sheikh is there. This is your matter? No.
My
Oh,
item is
Mr.
item
this
number
one, no,
12,
I'm
madam.
sorry.
I
Mr.
missed it.
A.M. Barbia. Okay, now it's okay. You're not there. You see, you projected that due to illness, you could not appear before the tribunal.
Sure.
That was a ground taken by you in the application for setting aside. Now, in the application for setting aside, the tribunal considered that plea And it was rejected on the ground that you have not, the period of treatment is not made in that medical certificate. And nobody came forward to prove that. And the nature of disease doesn't inspire us a confidence with regard to that nature of illness,
Hepatitis.
hepatitis. So again, you take the same plea in this writ petition. In now you further say that that order, you see, your lawyer did not advise you of your rights to challenge the impugn opinion. But thereafter, you filed an application for vacating, which was dismissed by order dated 12/12/16. 9 years has gone by. It is not your case that in your area there is only one lawyer.
Lordship, then maybe taken another day, then that day my senior Mr. A.M. Borguya will appear in this matter, Lordship.
Okay, what says are represented on the prayer made by Miss
A. Begum.
A. Begum, Zanet Housing for the petitioner. Magistrates adjourned today. List again on. Wednesday. Wednesday will be.
Much obliged.
Yes.
Well, look, regarding item number 12, my lord, if your lordship considered, my lord, my presence may be given. Relief already granted to me, my lord. I am grateful to your lordship.
Well, business, Mr. M.A. Sheikh.
Obliged.
But Mr. Sheikh, in this world of modern technology, we are already online.
My lord.
That you did not argue. You want us to record a false statement?
My lord. My lord, thing is this, my lord, actually, I am thinking that this earlier matter, my lord, your lordship said that another 5 minutes will be taken. But ultimately it is. My lord, in early hours, my lord, before break, my lord, I was.
We heard you. Now we have reheard you. And passing the same order.
Obliged, your lordship.
Yes, item 14.
May I please, your lordship. Lordship, it is an ex parte opinion on page 41.
41.
Yes, lordship. 41 is a type copy and vernacular is placed, my lord. Page 46.
Yes. What is your explanation?
Explanation on my lord.
Yes, lordship. I have noted.
noticed
lord-
it.
Yes, lordship. Earlier. Yes.
But we did not get any report from the authorities.
Lordship,
What they have
today
done,
itself, I am taking instruction, lordship, regarding that, lordship.
because every time we find
Yes,
this,
yes,
we are
yes,
paying.
lordship, yes, lordship.
Is
89 now.
we see this officer needs a stenographer. We
Lordship.
don't want this The only good thing is that the handwriting is extremely good.
Yes, Lordship.
I think this is by a copyist. Pinti Rajvamshi. Most appreciate her handwriting. Wonderful. But what is your explanation in the repetition?
Explanation paragraph 6, my lord, in page 8.
Six.
Yes, my lord. In page 8, no repetition.
It's not a good ground.
My lord,
You are able to accept this explanation.
Lord, is a illiterate person, my lord, due to ignorance of law, my lord. The advocate is not proper guided to the client.
We are also in search of a learned counsel like this.
Yeah.
Who will take all the responsibility of informing the clients. We have a lot of appointments to be made in the legal aid council. Council will go home to home, collect information, not take fees, file written statement. We are really searching for lawyers like that.
Yes, sir. That's true.
We have a lot of vacancies in a lot of appointments to be made in that legal aid council, legal aid section. Did you get time did you get time any time to read the Wakalatnama? Have you ever read the Wakalatnama? No. Read the last line of the Wakalatnama.
Yes, yes.
The lawyer is not bound to appear without
Yes, yes,
getting
that's
fees.
true, my lord, that's true.
Correct.
Correct, yes.
Yeah.
That's correct.
Then
Police?
what can we do?
I know this.
So you have to sue the bar council, the bar associations. Make that, remove that a lawyer once engaged. He'll have to appear. If we can have amendments like that to the bar council rules, we'll be very happy. Are you proposing to sue the bar council and bar associations all over the state?
That purpose I am not.
If you undertake, we'll issue notice.
That is question, my lord, I don't know whether he proposed to bar council or not, my lord, that I do not aware about this.
This is, you can't accept this explanation. Because once we accept this, we'll encourage forgery. You said that you gave all the documents and you are under the impression that the lawyer will file a written statement. Lawyer cannot file written statement under his signature, his or her signature.
Yes.
He'll have to take the signature of the client. If you expect him to file, that means we are encouraging forgery. That he will sign on behalf of the client and then file it.
Yes, just.
You can't accept this explanation. You can't have that expectations. Yeah. Again, Charles Dickens comes in. Great expectations. How we can't accept this? You wake up only when the police goes to your place.
Some time will be given, my lord. In this ticket, I want to take some information whether any application.
No,
if
that
we put the
information
bar
doesn't help
council-
you. The reason is that police went to you in, what do you call? When did the police went to you? 21/6/2025,
Recently, yes.
correct?
Yes,
Then you obtained this copy on 27/6/2025.
yes.
25, and we are now in February, again 6 months.
Twenty-seven, 6/25, obtained the certificate copy.
Yes. Then you come and file this writ petition. Let it remain defective for quite some time.
Yes, sir.
From November till February, you
Yep.
you keep it defective. Then you cure the defects.
No, earlier one time, my lord, it was
Five
the
on,
listed, my lord.
5/2/2026.
Earlier, one time it was listed before this honorable court, but due to period of time, my lord, not reach. The second time, my lord.
Now we are ready to hear if there is any election part of the learned council. You'll not argue on that drafts of the council now.
Yes.
You're not arguing. From November till February, learned council did not take steps in this court. You don't even serve copies to Mr. Sharma. You serve copies on Mr. Sharma only after the registry points out that you have not served copies. No, sorry, Mr. Hassan. We can't encourage that next idle approach.
Then some time may be given, my lord. So,
Both sides are represented. It is seen that at every stage, there has been an inordinate delay. And even in course of filing of this repetition on 7/11/2025, the defects were not removed. As in when, till 5/2/2026. Next. You also observe that the certified copy of the ex parte opinion was obtained on 27/6/2025. But this repetition was filed on 7/11/2025. That's what accordingly the learned counsel, Mr. F.A. Hassan, Commandant Counsel for the petitioner, pays for some time to obtain instructions. Matter stands adjourned today, list on when?
Next week, when it is.
Huh?
Next week, when it is.
Next week. 23/2/2026.
Right, student.
Item 15 or motion.
Yes, Mr. Ahmed.
My lord, petitioner earlier approached this honorable court. Lordship can see page 44, impugned opinion on 24/1/2019. Then
Where is the present opinion under challenge?
present, my lord, page 54, my lord.
Mr. J. Ahmed, name was for the petitioner, and so for the respondents. Opinion is at page 54. Okay, 12/7/2023, passed by so-and-so. FT case number so-and-so, reference case number so-and-so. Thereby declaring the petitioner to be a foreigner of host. Thereby approving the previous opinion passed by the said learned tribunal on 24/1/2019. By which the petitioner was declared to be a foreigner of post 25/3/1971. Issue notice returnable on so and so. Give a returnable date, returnable on so and so. Extra copies within 2 days. Call for the record from the learned tribunal to the following email address of the said learned tribunal. Next para. The prayer for bail shall be considered on receipt of the tribunal's records. Next para. In the meantime, if the petitioner, namely Jamshed Proceed Ali, TOMCR, Proceed Ali is apprehended, and shall not be deported out of the country without order of the court. However, the petitioner shall cause production of a certified copy of the order before the Superintendent of Police, Border Borbeta, to bring the order to the notice of the said authority. This law, so and so. 16th of March.
Item 16.
Yes, Mr. Ali.
May I please lost? Not the impugn opinion, my lord, page 53, my lord.
53.
Lordship. And ground, my lord, of disbelieving, my lord, paragraph 7, page 56.
Page number?
56, my lord, paragraph 7,
No, what is the explanation for the delay?
page 53.
No, explanation for the delay.
My lord, paragraph, my lord, 10, 11, my lord. Page 9 and 10.
And Mr. R. Khalil and counsel for the petitioner and so and so for the responsible. Opinion is at page 53, but at 7/11/2022. Passed by so and so in case number so and so. The reference case number so and so. Thereby declaring the petitioner to be a foreigner of post 25/1971 on stream. In view of the inordinate delay in selling the impugn opinion, keeping the issue of maintainability open, issue notice returnable on so and so. Extra copies within 2 days, call for the records with an email address. The prayer for bail shall be considered on receipt of the tribunal's records. In the meantime, if the petitioner, namely Begum alias Rohima Khatun is apprehended, she shall not be deported out of the country without order of the court. However, petitioner shall cause production of a certified copy of the order before the police border, Solipur, Tejpur. To bring the order to the notice of the said authority. List from Solipur.
Deep level.
Of March.
Item 17.
Made please, Your Lordship.
Which page is the opinion?
opinion is at page 149, my lord, annexure 41. The opinion was, my lord, passed by the member foreigner tribunal Bozal on 22/7/2025.
But Mr. N. Sarkar, Learned Counsel for Petition. And so also for the respondents. Page 141. Opinion dated 22/7/2025, passed by so and so in FD case number so and so. IMDT case number, it is in first line. I've underlined it. Thereby declaring the petition to be a foreigner of post 25/3/1971. Notice returnable in 4 weeks, call for the records. Extra copies in 2 days. The prayer for bail is opposed by the learned standing counsel for the FD matters, considering the transaction made in this rate petition. 10 days time to take bail of rupees 5,000 should be satisfied now. Equal to police. Property. List of the 4 weeks on the security groups.
Much obliged.
Item 18.
The impugn, my lord, the impugn final opinion, my lord, and it's page 16, my lord. 16, 16. And 11 portion, my lord, page 19, my lord, the ground of opinion, my lord. Page 19, Kaldisi, my lord. Considering the enter.
The prayer for bail is opposed by the learned standing counsel for the FD matters. Considering the projection, 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border, Sonitpur Page Group. This after 4 weeks.
Item 19.
Yeah, big lordship. Lordship, impugn opinion, my lord, is 79, my lord. There is a delay, my lord.
Page
79, lordship. 13/6/2019, my lord.
Nineteen, what is your explanation?
Page 23, my lord. Paragraph 24, my lord.
This is a statement very hard to believe.
Lordship.
In view of annexure 4 and annexure 5 to your
Lordship.
writ petition,
Lordship. And the four lordship, her father's name is here, madam, her name is here.
no, but your the explanation of delay
Lordship.
that becomes questionable in view of annexure 4 and annexure 5.
Her father had landed property, but they don't know. That is why. And the petitioner is aged about 64 years now. And a very poor and illiterate person.
This is not a good explanation for challenging the opinion after 7 years.
Lordship.
The, but we'll have to put you to notice that if you are making allegations like that against the
No, my lord.
tribunal, then you must give more reasons.
Lordship.
You have alleged 3 things against the tribunal: lacking knowledge, relying on technicalities,
Lordship,
and lacking of experience.
Lordship, in this matter, my lord, the evidence has not been discussed, my lord, in this matter. The 4 evidence has been
Shows that
not valid. There is no discussion much. Only exhibit is discussion, but nothing is discussed, my lord.
you have your mobile with you,
Lordship.
you search, there's a criminal trial
Lordship.
by one judicial magistrate,
Lordship.
somewhere I forgot where. There you will find that the entire trial judgment is in 1 page.
Maybe.
Find out, no, not maybe, find out. Open your mobile, search order in 1 page. And that has been approved by the concerned High Court. In 1 page in a criminal trial. Find out, find out, find out. If you need discussion, why we don't approve this? Criminal trial order in judgment in 1 page. Got it?
Lordship.
Mr. Tarakas, you have got it?
No, I'm starting.
A criminal trial judgment is the final decision
Very slow, man.
You got it?
Determining the guilt of the innocence of the accused based on the evidence and law, and it can be found on official government portal such as so-and-so.
No, I'm not on the text. It is only 1 page judgment, right?
It is not calm with it.
Is it State versus John Doe? It is
No.
then,
John Doe is unknown. That's English decision.
yes.
John Doe is not used here.
Is it, my lord, recent judgment, my lord?
Yes, yes, very recent judgment. I read.
15 February 26.
Yes,
Yes. That State versus John Doe.
State
What?
versus John Doe.
Yes,
There's just
1 page.
1 page.
1 page judgment.
John Doe is unknown,
Unknown. It's a case of theft, I think. It's a-
whatever be, but
Yes, one page, my lord.
1 page.
5 paragraphs.
so we live in a modern world. Why we need a discussion? When the court says, the tribunal says that once you exclude a particular exhibit,
Lordship.
then there's no connection. Exhibit E, I believe.
Lordship.
It says that if exhibit E is taken away, then your link doesn't match.
CAF is there, my lord, the Gauhati certificate also, my lord.
But that Gaon Panchayat certificate has a seal embossed. So that
Lordship.
goes,
In the Gauhati certificate also, my lord, same.
where is that document?
The Gauhati certificate is. Panchayat is 78, my lord, and
Panchayat
Bharnakula.
is, Panchayat contains the seal, the
Only
state emblem.
only.
Then
The Gauhati also, my lord,
where is it? Which page?
page 76, my lord, Bharnakula, and same thing, my lord. State emblem here, my lord.
Page number
Page 76, my lord.
76. You come to page 71. প্রকল্পে মই দিয়া প্রমাণপত্র এই ঘৰত মোৰ সহি প্ৰমাণপত্ৰ দেখা what is this word I can't read?
জন্ম সংখ্যা আছে মই মোৰ লাটৰ প্ৰত্যেকজন লোকক চিনি পোৱাটো সম্ভৱ
No,
নহয়।
no, no. প্ৰদৰ্শকে লিখা
পদাৰ্থক এই দিয়া প্ৰমাণপত্ৰ A1ত মোৰ চহী প্ৰমাণপত্ৰ দিয়া কথাবোৰ মই ভোটাৰ তালিকা চাই লিখিছো উক্ত ভোটাৰ তালিকাসমূহ মই লগত অনা নাই।
So even if it is there, it doesn't link you with your parents. Because that is a voters list.
The voter list with her husband, my lord, in 2016.
No, 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 no. Then you see your evidence, your own cross-examination.
Lordship.
Your own cross-examination shows that your name is not there in the voters list. It is there with the husband.
Lordship.
So how does voters list prove your existence with your projected parents?
Lordship.
Tell us.
That is not my lord.
No, no, no.
Yeah, this is up to your lordship, my lord, for consideration, my lord. As is the related person, my lord, the court has a discretion power, my lord. Yes, my lord.
Discretion of the exercise judiciary.
Lordship. And she is the related person and the aged person, my lord. Lordship. For your lordship consideration, my lord.
We had a doubt, that's why we are exploring the possibilities of finding out if delay can be condoned.
Lordship. Yeah. Long gap, my lord, 6.5 years, my lord.
Okay, we'll examine and pass orders in the chambers.
Lords. And in this matter, but I am relying on judgment, my lord, lordship for
Yes.
consideration. Paragraph 46, 47, 49, and 50, my lord. I have. Lord. On paragraph number 46, 47, 49, and 51. Before adjudication of this matter, my lord, lordship kindly look into it. Paragraph 46 is plus 35, my lord.
Page paragraph?
Paragraph 46, my lord, page 35. My lord. Page number is bottom.
46 doesn't go against you. 46 says,
Lordship.
while it is true that the courts have consistently held that undue delay in approaching the court can be a ground for refusing relief,
Lordship.
the courts have also recognized that in exceptional cases
Lordship.
where the impugned action is patently illegal
Lordship.
or affects fundamental rights, the delay must be condoned.
And the citizenship is Lordship.
It's not a fundamental right.
Lordship. And the
Because
what is-
you were questioned, your citizenship is being questioned, being a foreigner.
and 47 also Lordship kindly. Sir.
This is not a prescription. You see, you have been questioned on the ground of your being a foreigner.
Lordship.
The statement you make is that there was a delay in view of the fact that you are dependent on your husband, your
Lordship.
husband is a day laborer.
Lordship.
And then we find documents when we tell you about the annexure 4 and 5, that the land holding is more than 22 bighas.
In the name of Father, my Lord.
No, whoever it is.
Lordship.
So your father
Lordship.
having 22 bighas of land, is
Sometimes,
comfortable with
sometimes
with the son-in-law doing labor work.
sometimes it will not be given by Lord.
No, we don't want land to
Sometimes.
you. We don't say that give land to you, but
Lordship.
in 22 bighas, what does he do? He engages labor. Unless you can show that your father-in-law is absolutely strong to plow the land alone. If you can show that, we are ready to go there and see him working. You see, this improvement trust doesn't help you. The fact is that in this case, the urban improvement trust case is that the land of the parties were taken off.
Lordship. That is
Those
the
were
continuance.
sent to development, those lands were developed. And you were not given the respondent was not given a compensation. So that is a patent illegality. Because the fact that land acquisition must take place only after land acquisition payment is made under section 11 of the Land Acquisition Act. That was never done. So therefore, there's a case of continued
Continuance.
continued default on part of the state. It is under that conditions that the High Court accepted the writ petition, and the appeal before the Supreme Court of India was dismissed. So that's a patent illegality. The person cannot be deprived of his land without due process of law.
Kindly see the paragraph 50, my Lord.
50.
Lordship. Court has the discretionary power, my Lord.
No, discretion is there, but it
Lordship.
will be judicially exercised.
Lordship. This is up to your Lordship, my Lord. If your Lordship allow, then allow, and your Lordship dismiss, then dismiss. It's up to your Lord.
You might not have read because of cultural differences. Have you read stories about Mahabharata? Sorry, Ramayana? No. There, what happens is that there's a demigod named Hanuman.
Lordship.
He has the strength to jump to Sri Lanka,
Lordship.
but his powers to jump was
That's it.
taken away.
That's it.
He did not remember his powers. So therefore, that the Lord had to be pleased by way of a stuti, and then he recollected his power and then jumped. So we are at the same stage. You have to remind us of our power. Where do we get the power to do whatever we want? We have domicile swords everywhere. We have chains and fetters everywhere. We just can't do anything we want. And that's the reason why we are hearing you. If we do work at home, we'll be more faster.
Then I may be allowed to 2 weeks time, my lord, to file my delay. Grounds of delay, my lord, to explain how the delay will be caused by.
Both is represented. The execution of delay as made in this writ petition. Apparently does not satisfy the court in view of the inordinate delay in asserting the impugned opinion dated 13/6/2019. Accordingly, the learned counsel for the petition, Mr. A. Mubarak, learned counsel for the petitioner, praised for 2 weeks time to obtain instructions. Understands that don't today. Give a date, motion matter, give a date after 2 weeks. You take back your citation of urban improvement.
My lord, I stand corrected. Being in a hurry, my lord, it
It's
escaped
okay.
my notice, my lord, that it was an illustration of the AI, my lord. Original, my lord, case I could not find.
No, it's
Yes.
there. We'll give it to you, just a
Yes,
moment.
yes. My network is, my lord, little being slow, my lord, it's not
No, it's
showing.
okay.
Yes.
We will just give you.
Yes.
11th of March.
জানি থৈ দিওঁ কি আছে কেছটো আধাৰ চাইডত থাকিলে আমাৰ কামত আহিব
No, even today we are not getting it.
Yes, yes.
It came in the live law.
Yes, live law, okay.
Give me the live
I'll also search on.
It came in the live law.
Relating to which high court, my lord?
I forgot.
my lord.
I read so much.
I'll also try to.
times.
I'll also try to.
We just forgot.
Yes, yes,
About 7 to 10 days back.
my lord.
It was there in the
Live law, okay.
the one page order of the
Trial court.
trial
Trial
court
court had
was
been-
approved by the High Court,
High court, my lord. Yes,
appreciating the concise writing
precise, yes, to the point.
to the point. We did not want to upgrade our skills to that effect, and therefore you did not keep a track of it.
My lord. No, I thought, my lord, it's
Unless-
proper to inform your lordships, my lord.
No, it's
because-
okay, thank you.
Because the misinformation, my lord,
Unless,
I
no,
mean,
it's okay.
Mm.
Unless the bar approves our short orders
my lord.
for
Correct.
dismissal of writ petitions,
Yes, yes, yes.
it did not.
Yes, correct. There are orders of the Supreme Court also assigning reasons, my lord, to elaborately assign reasons.
My lord. Sorry to trouble your lordship. Item number 14, there is so much to PIL. We have filed one affidavit, that is not in record, I've seen. May I request for lordship to bring a record this affidavit?
You want to call it? You want to
Pardon?
call that affidavit?
No, I'm praying for lordship for to call the affidavit. Please. Item 42.
Yes, item 21.
Item 21.
May please, Lord.
Yes,
My lord, this is the second time the petitioner, my lord, is compelled to, my lord, approach your lordships, my lord. Look, what has happened, my lord, very unfortunate. The lady, my lord, before your lordship, she is unnecessarily entangled, my lord, in a DRT proceedings, in respect of which, my lord, neither she is a borrower, my lord, nor she is a guarantor. And in her absence, my lord, being a totally stranger, my lord, to that proceedings, the DRT proceedings, my lord, was, my lord, on, and thereafter, my lord, a recovery certificate was issued against her flat, which has nothing to do with any loan, my lord. And thereafter, my lord, when the officials of the bank, my lord, went to attach the flat, my lord, she came to learn that there is a recovery certificate.
just a moment.
My lord.
We missed out something, just a moment. Just a moment. Yes,
May please, Your Lord. My lord, in fact, it's a case where, my lord, a recovery certificate in respect of a flat has been issued, my lord, without making the petitioner a party, and against which, my lord, the petitioner has no loan, nothing. 2-3 dates would be relevant, my lord. Then I'll proceed further.
See, can you come to page 60?
1660.
60. Yes,
My lord.
second paragraph, last 4 lines.
My lord.
The defendant number 1,
Yes. Defendant number 1 denies the correctness of the statement of account.
no.
My lord.
Page 60.
60.
This first paragraph which ends at third party. Then there's a second paragraph, the further contention.
Yeah.
There last 4 lines.
Last 4 lines. The defendant number 1 further averred that she is very much ready to repay the loan of the applicant bank, provided the pro forma defendant number 3 executed final sale deed of flat number 502B at Ashana Enclave and also delivered the said flat to the defendant number 1. My lord, here
Who is
I am
this defendant
Moni
number
Devi.
one?
I am Moni Devi, my lord. I have nothing to do with all these defendants because this entire proceeding, it was proceeded, my lord, in my absence, my lord. Now, what has happened, my lord? My lord, my lord, briefly state 3-4 dates, my lord, which will, thereafter it will become clear. My lord, I purchased the flat in question in Ashiana Enclave. There was an agreement for sale, my lord.
On 27/10/2006, I have annexed, my lord, the agreement. It is at page 79. Thereafter, 27/10/2006, my lord.
Yes.
Thereafter, my lord, the sale deed was executed on 7/2/2007. The sale deed, your lordship will find at
2000?
page 90, my lord.
2007.
2007, my lord. So hardly after, for my lord, 4 months of
This is
the,
that page.
it is at page 90, sale deed, my lord, I have annexed, registered sale deed. Now, my lord, before proceeding further, 2 dates are very relevant. What has happened, my lord, on 26/4/2006, before I entered into agreement, the respondent 2, that is the defendant 1, my lord, she entered into an agreement with the builder in respect of the same flat on 26/4/2006. These are all, my lord, based on records. So there is no dispute in respect of, my lord, these facts.
What is the date of agreement for sale?
The, my lord, borrower and the builder, they entered into an agreement on 26/4/2006 before I entered into an agreement. Deed number 2131/06.
Builder and borrower.
Borrower, my lord, the respondent number, my lord, here your lordship will find respondent number 2. That is the defendant number 1 in the original application. And thereafter, my lord, on 2/6/2006, this particular deed was cancelled by way of a registered deed. 2/6/2006. Deed number 5595/2006.
Where is
So-
that?
Yes, this will, my lord, I can show, my lord, from the order. I'll come to that, my lord. But before that, now pursuant to this one, my lord, pursuant to cancellation of deed, I came into the picture. Your lordship will see my registered deed is on 27/10, pursuant to this cancellation. So pursuant to the cancellation, I, my lord, came into the picture. Now what had happened when the, my lord, pursuant to this agreement, my lord, loan was taken by the borrower, and my lord, it was, my lord, delivered to the amount was deposited to the builder. And subsequently, no installment having been paid, my lord, the bank proceeded against them. And by that time, my lord, I was already in possession by way of the sale deed, due to the, my lord, cancellation. Now in 2016, when the bank, my lord, pursuant to the recovery certificate, came to my house for attachment, I came to know about this, my lord. Then I immediately, my lord, this your lordship will find at page 91, I approached the recovery certificate, who was, my lord, executing, my lord, the execution case at page 91, my lord. This will reveal the facts, my lord. These 2-3 orders, my lord, are important, my lord. Your lordship will permit me to read it out. Is page 91, Annexure 8, my lord, order dated 23/9/2015. May I read it, my lord?
Don't read it, just tell us what is there.
Here, my lord, your lordship will see, I appeared. Then, my lord, this was observed by the recovery officer. Your lordship will come to, my lord, 4th paragraph. Following facts have come up from the various documents filed by CD number 1 and Srimati Moni Devi and records available with the case record. Number 1, a memorandum of agreement was signed between the builder and the CD number 1 for sale of a flat being numbered 502B of Ashiana Enclave, situated at Moza so-and-so, deed number 2131/2006. However, the sale deed was not executed and registered. The CHB disbursed, that is the bank, 9,60,000 to the builder out of the sanctioned loan amount. However, the builder did not execute the final sale deed as per indemnity bond executed by him. The builder has also received 1 lakh by receipt number so-and-so and further 1 lakh by receipt number so-and-so. Thereafter, my lord, on 2/6/2006, both the builder and CD number 1 executed deed of cancellation. This one, my lord. And same was registered as deed number 5505/2006. Thereby, both the parties agreed to sell the mortgage property to another person, that is me, my lord, and agreed to cancel the deed number 2131/2006 that was mortgaged to CHB. Thus, CD number 1 forego her right over the mortgage property, but neither the CD number 1 nor the builder had returned the loan amount taken from the CHB after cancellation of the deed number 2131/2006. They even did not inform the CHB of such cancellation agreement. The builder and the CD number 1 both signed another deed of agreement on 2/6/2006
whereby the builder agreed to sell flat C type measuring 1033 so and so of Ashana Enclave numbered as 503C, and the said agreement was registered as deed number 5506 of 2006. However, till date, the builder has not executed the sale deed of the flat in favor of CD number 1. The builder later on sold the mortgage property flat number 502B, changing the flat number to 502 to Srimati Moni Devi. Well, here I come in. By deed of agreement dated 27/10/2006, and the same was duly registered. The builder also executed sale deed in favor of Srimati Moni Devi in respect of the mortgage flat. The above mentioned fact reveals that the builder has received 9,60,000 from CHB, rupees 2 lakh from CD number 1, and sale consideration from C Moni Devi for the same flat, and he has not executed sale deed in favor of CD number 1. That is the
We are not being able to follow you because of the fact that come to page 93.
my lord. I'm reading 93, man.
Yes, in 93, what was attached is 503C.
See, correct,
And page 97,
correct,
scheduled property is 503.
correct.
You are owner of 502. How you are aggrieved?
Yes, yes. That is why. My lord, in fact, the recovery certificate, which your lordship will find, my lord, in the original application, that is in respect of 502B. I take your
seen
lordship's, my lord.
You've seen that? That's why
Yes.
we are asking you that question.
502B. Now, what has happened, my lord? After the attachment order by the recovery officer in respect of 503, my lord, all these orders would go to show, my lord, nothing had happened. Thereafter, I annexed this order, my lord, which starts from, my lord, page 98. These are orders of the recovery officer. Now, pursuant to these attachment orders, nothing happened. At that point of time, my lord, since the recovery certificate in respect of my flat was hanging over my head, I approached this honorable court. And thereafter, my lord, the dividend bench of this honorable court, if your lordship comes to page, my lord, 34, pass this order, my lord.
Who is Kumar Anshuman? Who is Kumar Anshuman?
Where your lordship finds that one, my lord?
This page 127.
127.
Oh, he's the branch manager. Okay, okay.
My
No,
lord.
no, not you. I thought I'm wrong.
My lord.
Okay.
So if your lordship sees, my lord, the order of the High Court, the honorable court, my lord, I may read from page, this starts from page, my lord, 34. I may not burden your lordships with the facts, my lord. If your lordship comes to para 7, these are the relevant part of the order at page 36. Order dated, my lord, 15/9/26, passed in writ petition 5534/16, my lord. From para 7, my lord, 3-4 paragraphs, your lordship may allow me to read, my lord. Page 36.
Yes.
The above narratives clearly reflects that the petitioner is a stranger to the loan and purchase flat 502B, has nothing to do with the loan transaction between the bank and the borrower Mosumi Bora. Moreover, in respect of flat 502B, no security interest has been created, and therefore the same cannot be subjected to attachment under the SURFACE Act. Well, this should be DRT Act, but nonetheless, nevertheless, the threat of reattachment of the flat 502B on account of the recovery certificate 5824 in the OA 48/2008 has prompted the bona fide purchaser to approach the High Court. We notice that the certificate officer of the DRT has already clarified that the security interest is created in respect of flat 503C, and therefore the attachment of the petitioner's flat 502B of Asiana Enclave can never be justified, as the earlier judgment of the DRT rendered on 37/14 in the OA 4/2008 proceeded on the erroneous premise.
After this, what has happened?
Yes, my lord, yes. I take your lordship to para 9, my lord. Kindly your lordship will come to para 9.
No, we're saying that the court
Yes,
said that.
here, my lord, it says the petitioner is allowed to apply for clarification from the DRT in respect of
Yes.
the order passed in so that appropriate clarification can be given on the charged property by the DRT. Until such clarification is given, flat number 502B purchased by the petitioner in the Asiana Enclave should not be attached or proceeded pursuant to OA so. It is ordered accordingly. So this was the direction, my lord, to the DRT to clarify.
Yes.
Thereafter, my lord, I filed the MA miscellaneous application, I have annexed here with my lord, which your lordship will find my miscellaneous application starts from my lord page 102. And this was registered as Miss Case 50/2017. Now here your lordship will see it, my lord, indicates very clearly, it reflects, my lord, an application in terms of the order dated
Just now.
50,
Page number?
page number 102, my lord. It was registered as Miss Case 50/17 in OA 4/2008. And my lord, the cause title shows an application in terms of the order dated 15/9/16 of the Honorable High Court passed in WBC 5534/2016. And in page 104 of the said application, your lordship will see the order of the Honorable High Court was also annexed as Annexure 1. Now, my lord, this miscellaneous application was heard several times. In fact, my lord, I had taken notice on all the parties by registered post. Despite receipt of notice, the other respondents, my lord, more particularly respondent 2, who is the borrower, respondent 3, my lord, her husband, the guarantor, and respondent 4, builder, they had chosen not to appear before the DRT. And subsequently, my lord, the DRT directed to make me a paper publication. That was also, my lord, made. Paper publication was also made. Eventually, my lord, the State Bank of India appeared and it had filed its objection, my lord. Now, after, my lord, a lengthy hearing, the learned DRT, my lord, came to the conclusion that, my lord, this application is not maintainable in view of the fact that it would be amounting to review the order passed by the, my lord, earlier predecessor or issuing the recovery
Where is
certificate.
that order?
Yes. That order starts from page 151, my lord, Annexure 17. My lord, if I take your lordships, my lord, to the
Why there's a delay of more than a year in filing this present writ petition to challenge the order dated 22/1/26?
no, my lord.
You're challenging order dated 22/1/26.
Yes.
Why there's a delay of 1 year?
No, my lord. I have filed recently. Your lordship will see the date in the affidavit. I have filed on, my lord, 4th February 26, my lord.
Oh, this is 26, okay.
26.
Sorry, I'm reading it.
Yes, sir.
25.
My lord.
I'm sorry.
My lord, instead of going through the entire order, if I take your lordships, my lord, to page 161, which I think would be relevant, the second para, my lord, from 161. These are the reasoning of the tribunal for rejecting my application. And now, my lord, by this order, I have been rendered remediless. Heard the learned counsel appearing on behalf of both the parties. Admittedly, the respondent number 2 of the misapplication had availed loan, that is the borrower, my lord, not me, from the respondent 1 bank to purchase flat, a mortgage flat being 502B in the 5th floor of Ashiana Enclave, in favor of the respondent bank to secure the loan. And when the borrower had defaulted to repay the loan, the respondent 1 bank as secured creditor had approached this tribunal by filing an original application number so-and-so under section 19 of the DRT Act. Thereafter, on 30/7/2014, after completion of pleadings and after hearing the parties, the tribunal had passed the judgment and issued recovery certificate being RC number 1436/14. Since the applicant was not a party to the case and not related to the respondent bank, she is not entitled to receive any notice from the tribunal and the matter was not proceeded ex parte against her.
Here again, Mr. Taluk, the same problem is arising. You come to page 155.
155.
Again, this issue of flat number 503 and 502.
Yes.
Please explain this.
Page 155.
155, there's a reference of taking physical possession of flat number 503.
Yes.
503 is not yours.
503 is not mine.
Last part of the order, it says if of the 502 would be attached. So how does this apprehension come?
I don't get your lordship's, my lord. May I?
See, in page 155.
55.
About 6-7 lines from top.
My lord.
The physical possession was being taken off flat number 503.
Yeah.
Correct.
Now,
Now,
by order dated so and so, huh?
yes.
Yes.
Come down about 7-8 times from below.
My lord.
You will find the 10 lines, the
Right.
applicant thereafter immediately attended so and so, informed the applicant that 5.2 would be attached. So how does this apprehension come?
The applicant thereafter immediately attended the recovery officer who informed the applicant, belonging to the applicant would be attached on the next date, i.e. month, as in the meantime, the other flat, namely so-and-so, has been sold by the builder to some other person. My lord, this is not part of the pleadings. I don't know how it comes. I came to the High Court that there was a recovery certificate against my lord, an attachment order against 503. But since, my lord, the recovery certificate was already, my lord, existing in respect of 502. So therefore, I sought for the clarification whether or not the DRT would proceed against me. And this Honorable High Court said, my lord, directed the tribunal to clarify. Had there been a clarification that the DRT would not proceed against 502, then, my lord, I am free. But instead of making that clarification, my lord, with all respect, the DRT, my lord, totally, my lord, defied the Honorable Court's direction to make a clarification. I am not saying, my lord, that the clarification should be in my favor. But at least in terms of the High Court's direction, a clarification was warranted, my lord. But no clarification is made, saying that the petition is not maintainable. This is not a review application. It is amounting to review the order. And the other ground is, I have not made a prayer for clarification. Assuming, my lord, that there is an inadvertence in my prayer. Assuming I have not made a prayer. But that will not, in my respectful submission, detain the DRT, my lord, from, my lord, not making a clarification. Because under Article 227, your lordship is aware, the tribunal is under the jurisdiction of this Honorable Court. And defying the High Court's order, it is amounting to act, my lord, in excess of its jurisdiction. How can it, my lord, not comply with the directions of this Honorable Court, my lord? Your lordship will see my MA has been dismissed without any clarification. The operative part, your lordship will find.
Just a moment. Green flag, page 396.
My lord. Yes, I stand corrected, my lord. Under this High Court Rules 1992, my lord, the DRT Act, my lord, does not come. It is correct, my lord. But, my lord, there is an order of the, and DRT Act is of 1993, my lord. And this rules of 1992, my lord, I don't know, my lord, whether it has been subsequently amended or not. I take it for granted. But, my lord, my humble submission
You
is.
can take it from me, it has not been amended.
No, not amended. I take it from your lordship, my lord. But my humble submission is, my lord, the order, my lord, of the Honorable Court in the earlier proceedings, my lord, is absolutely clear, my lord. This is a direction, my lord. And therefore, my lord, being under the jurisdiction of this court, my lord, the tribunal could not have, my lord, rejected my application without making a clarification.
Where is that operative part?
Yes, operative part, your lordship will kindly come to page 164. Last, my lord, 4 paragraphs from below, my lord, 164.
Recovery of debts. Recovery of debts. Oh, it's a-
My lord, by this time, there is a development also. During the pendency of my misapplication, the builder had, my lord, paid all the, my lord, principal amount. It reflects from the order. Now, the bank does not owe, my lord, any principal amount, only the interest part. So at this stage, my lord, it's only a matter of discussion between the bank, my lord, and the builder. How much, my lord, interest is accrued, how much, my lord, they will take, my lord. So that settlement eventually, my lord, would absolve my lord, everything from this, my lord, case, everyone. And that clarification was sufficient, my lord, because I am entangled unnecessarily. This is nobody's case. The tribunal had not, my lord, observed that I have taken the loan. Tribunal has also observed, my lord, that I am a stranger to the proceedings. I have not taken any loan. So my flat 502B is unnecessarily entangled due to the recovery certificate, man. And the builder has taken the entire money. Now only the interest part is, my lord, remaining. And builder has said, my lord, if your lordship comes to
No, just see the, take us to the operative part of this.
page 164, my lord.
164.
Yes.
Yes.
164, my lord, 4 para from the bottom. In view of the above discussion, I find and hold that.
Just a moment. Just a moment.
Yes, my lord.
Yes.
In view of the above discussion, I find and hold that the application is devoid of merit and is liable to be dismissed. Accordingly, MS so-and-so is dismissed and disposed of. Only on 2 grounds. Firstly, if we accept, my lord, this application, it is amounting to review. And number 2, there was no prayer for clarification, my lord. Only on these 2 grounds, my lord, I, in my respectful submission, absolutely flimsy ground, my lord. Kita pang High Court rules of asan natin? Superintendent of Provisions. Kung lagi sila possibility. Hindi na lagi yun. My lord, I will try to understand more clearly rules of 1992. But here, what the definition of tribunal, my lord, is here, my lord. I'll stand corrected, my lord. I'm just asking this question to myself, my lord. Tribunal means in the northeastern states, which are included in the schedule, this schedule, my lord, attached thereto, and all other tribunals over which the High Court has the power of superintendence under Article 227 of the Constitution of India. Perhaps subsequent line, my lord, will bring the DRT, irrespective of, my lord, the schedule. That I'll try to, my lord, understand more clearly, my lord. Yes, yes, correct, ma'am. I'll try to understand more clearly, ma'am. I have not gone through this, my lord. Right.
There cannot be a presumption of.
Correct,
process.
that is correct. But, my lord, the provision of, my lord, the 227, the Constitution, perhaps, my lord, that cannot be excluded, my lord. This is
We
the,
would have been happy to take up this, what you call, what you call, Ordinance Tribunals Matters under 227. We are not doing it.
yes, correct, correct. That is correct.
The Supreme Court had to create an exception in N. Chandra Kumar's case in saying that in CAT, it has to be by a challenge before a division bench.
Yes, that 1997 Supreme Court.
That perhaps.
That's correct, correct. I stand corrected, my lord. Yes, that is why, my lord, I did not go through this rule. My lord, I'm obliged, my lord.
It's okay.
Yes, yes. Correct, my lord. That is correct.
See, there are two things operating against you. That one, there's a recent judgment of Supreme Court,
No.
2022 or 23, not recent, but recent times that judgment is there, saying that the High Court should refrain from interfering in the matters related to the death recovery tribunals.
Correct.
I really don't have the citation, but 22, I think.
Correct, my lord. I understand, my lord, because there is a
Yes.
provision for appellate tribunal. I
Yes,
understand.
That's one.
Yes.
Second is that it is in that context that the Supreme Court says that there should be restrained, judicial power should be
Yes.
restricted use. That's one. Second point is that in your application which was made,
Yes.
which you are showing at page 102,
My lord.
have you taken a ground that the act of the recovery officer is fraudulent, or the banks taking over of the secured, the taking of the security assets
My lord.
and its consequent sale is vitiated by fraud? That's not there.
My lord, in fact, with all respect, my lord, I have taken a ground, my lord, that the proceedings in OA, my lord, I was totally a stranger. That ground I have taken. But on fraud, my lord, I did not go. But your lordship will see, my lord, this is the power of the, my lord, tribunal, section 22. The power, my lord, it is not that the power, the tribunal is denuder of the power. When the tribunal finds that an application, my lord, or a recovery certificate is passed ex parte, it has the power to set it aside. Under 22G, my lord. 22, procedure and power of tribunal and appellate tribunal. If your lordship comes to...
That's not, you have not invoked that.
No, my lord, what I was on, the honorable court directed me, relegated me back to the, my lord, tribunal. And in my written argument, I have stated all these things. If your lordship comes to my written argument, all these, my lord, points were ignored by the tribunal. This is one of my ground, my lord. If your lordship comes to page 150, ground 8.
Written argument, you will find it in OCRPC 313, I think.
My lord, these are point of law. In fact, my lord, this is not based on facts.
No, not that. Maybe what happens to a written argument.
My lord.
You see, we'll tell you why we don't.
And if your lordship sees the other grounds in my application, 502, my ground was that so far as my lord, the property is concerned, a security interest is a sine qua non. Because the moment the agreement for sale was cancelled by way of registered deed, my lord, my lord, flat became free from hypothecation or mortgage. There was no mortgage at all. So security interest in terms of the DRT is a sine qua non for proceeding against my lord that property. There was no, and this is my ground in paragraph 12 of the application, my lord. No security interest was created. And my lord, the oral argument, memorandum of argument.
The 114(1) last part.
14. Yes,
314.
I have subsection 4, my lord.
314.
14.
1.
14.1, last part. Any party to a proceeding may be, after close of his evidence, address concile or an argument, and may, before he concludes the oral argument, if any, submit a memorandum to the court, setting forth concisely and under distinct headings the arguments in support of his case, and every such memorandum shall form part of the record.
It goes to the record.
Goes to the record, my lord. Every such memorandum shall form part of the record. That will form part of the record, my argument.
That's all.
Yes. Well, now it is part of the records, my lord.
That's all.
Yes,
No prescription of reading it.
my lord.
There's no prescription of reading it. That is why we hear an oral argument always.
My lord.
This is in a lighter note.
My lord. My lord, in fact, your lordship will see at the end of the day, my lord, I am suffering from no fault on my part. Without any fault on my part, and due to the mischief, my lord, of the borrower and the builder.
the change of flat number to sell it to a third party, what was that scope we forgot?
My lord, in fact,
Somewhere it is there that the builder had changed the flat number and sold it to a third party.
no, third party minus means me. That is the third party. Between the borrower and builder, first party, second party. And third party is me, my lord.
To sell it to you, they change the flat number.
It was, my lord, 502B. When the loan was taken by the borrower, it was 502B in the deed of agreement. And after the cancellation of the deed, I entered into the picture. Subsequently, flat was sold to me as 502 only. And this is reflected in the recovery officer's order, my lord. The 502B is sold to the third party, that is Moni Devi, as 502. My lord, if your lordship sees page 94, the order of the recovery officer, here the breakup is given and the principal amount is indicated, my lord. Page 94. After the breakup, my lord, this is Mr. Atikur Rahman, that is the builder. He says, my lord, Mr. Atikur Rahman has expressed his desire to settle the matter with the CHB, that is the Certificate Holding Bank, that is the State Bank of India. And subsequently, my lord, he had paid the principal amount, 9,16,000, and two other principal amount, 1 lakh, that is 11,16,000. He had paid, my lord. That principal amount, my lord, has already been paid. If your lordship comes to page 136.
Interest is 125% of the principal.
Now that interest, my lord, the State Bank and the, my lord, builder, they will settle because the amount has been taken by the builder, my lord. He is liable to pay. And this is the order, my lord, 18/12/2017. Your lordship will see. See, Atikur Rahman has deposited a check bearing number so-and-so of 11,16,000. The principal amount has been cleared, my lord. So merely it's a matter of, my lord, interest. And I'm unnecessarily entangled, my lord, in all these things without being a borrower, without being a guarantor, nothing, my lord. Unnecessarily from 2016 onwards, my lord.
Good. Mr. S.K. Tamudal, counsel for the petitioner. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated, order dated 22/1/2026, passed by the Debt Recovery Tribunal, Gauhati, in MA number 50/2017, within bracket, in OA number 4/2008. Next one. In brief, the case of the petitioner is that she is neither the borrower nor a guarantor to the loan avail. It's a housing loan.
My lord, SBI,
Housing-
from SBI.
Housing loan availed by respondent number 2 from the respondent number 1 bank, of which the respondent number 3 was a guarantor.
My lord.
Most of the said property is the property for which loan was availed is a flat of which the respondent number 4 was the builder.
My lord.
It is projected that by way of an agreement for sale dated, registered agreement for sale dated 27/10/2006, the respondent number 2 agreed to purchase the flat
That is,
serial number 502 within bracket small b or capital B?
my lord, the borrower took the loan on 26/4/2006.
26/4.
4/2006.
No, you
This-
said 27/10/2006 is the
Thi-
agreement.
This is my agreement for sale, my lord.
That is
I-
your agreement.
Yes, I have subsequently entered, my lord.
26/4/2006.
Yes.
This is, what is the flat number here?
My lord,
In this 26/4/2006, what
Yes.
is the flat number?
this is flat number 502B, my lord.
502, capital
B.
B, small b,
Capital B.
502, capital B.
Deed number 2131/06. Registered deed number
Bearing registered deed number
2131/06, my lord.
31/2006.
Yes. And this was cancelled, my lord, on 2/6/2006.
The said agreement for sale was cancelled by another registered deed
Yes.
dated 2/6/2006.
Number 5595/06.
55/2006. Full stop. Subsequently, by a registered agreement for sale dated 27/10/2006, bearing number
My lord, that I'm giving the number, my lord.
Okay, just hold it for some time to give it later on.
Yes, my lord. I'll give it. I'll give it. This is in the order itself. I'll give it.
The petitioner entered into a agreement for sale for purchasing a flat which was shown as flat number 502 in the said agreement. First off, on complete payment being made, a registered sale deed was executed on 7/2/2007 by the registered agreement number so and so. And the petitioner was handed over the physical possession of the said flat. Full stop. Without any notice to the petitioner and without arraying her as one of the respondents, State Bank of India had instituted a recovery application before the Debts Recovery Tribunal from Gauhati, which was registered as OA number 4 of 2008. And the said learned tribunal by its order by its judgment and order dated 37/2014 directed a recovery certificate to be issued against the respondent numbers 2, 3, and 4. To an extent of rupees 14,79,400. No, not to 20, not with penalty and future interest at the rate of 9.25% per annum with quarterly rests from the date of filing till realization. Accordingly, recovery certificate was prepared. Next one, it is projected that in course of time, in or about July 2015, the recovery, what is the time? Recovery,
My lord, in 16, they approached my flat, my lord. Thereafter, thereafter I approached this honorable court, my lord.
after the recovery officers exhibit the back of the petitioner for enforcing the recovery certificate. And they became aware that the petitioner was occupying the flat number 502 and that there was no flat numbered as 502 capital B. Accordingly, the petitioner appeared before the Learned Debts Recovery Tribunal pursuant to order dated 3/8/2015 passed by the recovery officer Roman 2, Debts Recovery Tribunal, Gauhati. And filed two petitions for impleading herself as a party to the recovery proceeding and for personal appearance, which is recorded in the order dated 8/9/2015. Stop. Next, consequently, the petitioner had filed all documents to show that he was not neither the borrower nor the guarantor of the said loan. And she had purchased the property being flat number 502 by way of a registered sale deed dated 7/2/2007. Next one. The learned counsel for the petitioner has submitted that in the orders passed by the recovery officer, Woman 2, of Debt Recovery Tribunal from Gauhati, or the said learned tribunal had the recovery officer had acknowledged. Where is that order? Recovery officer observation.
My lord,
Recovery officer observation is at page.
recovery officer order, my lord, it starts from
That you showed us that he admitted that he was not a borrower. Where is that?
yes. It's order dated 23/9/15. It starts from page 91, my lord. And the operative part is page 93.
And it's they submitted that in its order dated 23/9/2015 from the recovery officer to DRT Gauhati has categorically recorded that there was no sale deed executed in favor of the respondent number 2. And that subsequently the builder, i.e. respondent number 4, has changed the flat number to 502 and sold it to the petitioner. It is stated that by the said order dated 23/9/2015, the liability of recovery was shifted to the response number 4, were ordered to be liable to return the principal sum of rupees 11,16,000 with interest at the rate of 9.25% per annum with quarterly rests from the date of receipt till realization. And the attachment was made to flat number 503, was ordered to be made against flat number 503, capital C, of the said building. Stop. Accordingly, it is submitted that the respondent number 4 was treated as a garnishee by the recovery officer 2. Stop. Thereafter, the petitioner approached this court by filing a writ petition, which was registered and numbered as WPC 5534 of 2016, and the division bench of this court, by an order dated 15/9/2016, noticed that the certificate officer of the Debt Recovery Tribunal had clarified that the security interest was created in respect of flat number 503 within bracket capital C, and therefore held that the attachment of the petitioner's flat number 502 within bracket capital B of the said building was the said building can never be justified. And accordingly was of the opinion that under such circumstances, the Debt Recovery Tribunal should clarify the position in respect of the property, for which the charge was created for a loan sanctioned to the respondent number 2. The para 9 of the said order, which contains the direction of this court, is quoted below, page 37, para 9. Status. Had filed an application before the Debt Recovery Tribunal from Gauhati in terms of the order dated 15/9/2016, passed in WBC 5534 of 2016, which was registered as miss case number 50 of 2017. the learned tribunal Legislative Tribunal from Gauhati by order dated 22/1/2026, passed in MA number 50 of 2017, which is the impugn order in this writ petition. After having discussed the issues, the matters in its entirety, took a view that the application amounted to a review petition and held that a review petition, that the review is not an appeal in disguise. And passed the filing, following operative direction, or operative order. This is at page 163. One sixty, 164. Next paragraph. On next one. Having read the observations made in the operative part of the impugn order, the court has examined the prayers made in this, said miss case number 50 of 2017, which is extracted here in below. Page 115, 116. Next one. Therefore, from a privacy appears that the prayers made in the said miss case number 50 of 2017 went beyond the directions contained in the order dated 15/9/2016, passed in WBC 5534 of 2016. Next, be that as it may, the court is conscious of the fact that there are several orders passed by the Supreme Court of India on the point that high courts in exercise of power under Article 226 of the Constitution of India could not interfere with the recovery proceedings initiated by the Debt Recovery Tribunal for recovery of bank dues. Next, nonetheless, at the same time, court cannot be oblivious of the fact that in this case, there is a definite finding by the learned, by the recovery officer too, of Debt Recovery Tribunal, that the petitioner is neither the borrower nor a current. And the security interest is transferred to flat number 503 C. And by treating the respondent of 4 as a parachute, our directions were made recovery of the amount from the respondent number 4. So it may be stated that the learned counsel for the petitioner has submitted. In the meanwhile, the principal dues has already been paid by the respondent. And it is only the recovery of interest part of the means. Accordingly, as it is noticed that in the cost title of the list case number 50 of 2017, it has been mentioned that by the petitioner that the application was made in terms of order 15/9/2016, passed by this court in WBC 5534 of 2016. The court is inclined to issue a limited notice to the respondents to focus as to why this late petition should not be partly allowed by either permitting the petitioner to file a fresh application in terms of orders of 15/9/2016, passed by this court in WBC 5534 of 2016, and why the said order dated 22/1 to 2026, passed by the Debt Recovery Tribunal, Gauhati in MA number 50 of 2017, in OA number 4 of 2018, could not be set aside just to direct the said learned tribunal to pass orders, particularly in terms of the directions contained in the order dated 15/9/2016, passed by this court in WBC 5534 of 2016. Accordingly, the probably we should notice returnable on. Give it 8. 6/3/2026. So the petitioner shall take steps by 17/2/2026 for service of notice on the respondents by speed post. With AD and or by courier service, as well as by a courier service, private courier service. In the meantime, until the next date of listing, the Debts Recovery Tribunal is directed not to disturb the physical position of the petitioner over the flat number 502. Which is held in the name of the petitioner, pursuant to registered seal deed dated 7/2/2007. The interim order shall be revisited on the next date of listing. Next, the petitioner is directed to produce a certified copy of the order before the recovery officer from a debt recovery tribunal of Gauhati in connection with the proceedings of the proceedings pursuant to recovery certificate passed in OA number 4 of 2008.
I'm deeply obliged.
You have invited trouble for yourself.
Right.
By saying something more, you have invited trouble for yourself. Your prayer was not in terms of that.
Correct. That prayer was not correct. In the application, correct. That is correct. My lord, 2, 3 and 4, they had chosen not to appear. If your lordship permits, I can take paper publication also. Oh, correct. I'll take the steps, my lord, by respect.
I read newspapers daily,
None.
but I have
No, but-
never read a newspaper
No,
to
but-
find out my name in the
Yes.
debtors column.
No, apart from register post, I'll
No,
take
not
register
that.
post also.
No.
My lord, obliged.
Substituted service must be substituted in a
Correct.
manner prescribed under Order 5 Rule 20.
Correct. I'm obliged, my lord.
And not jumping sequence.
I'm obliged.
Do
Deeply
you
obliged.
ever read a newspaper for finding your name in the recovery column?
No, nowadays, my lord, I have dispensed with that. My lord. I don't read newspapers, my lord.
So how do you expect others to read it?
Correct. That is correct. Obliged, my lord.
Supply item 51 for motion.
Which is a lawsuit.
Yes,
My lord, impugned order is at page 54. Lordship.
54.
54.
Mr. M.I. Hussain, done pass for the petitioner and so for the respondents. Opinion is at page 54 of dated 17/3/2023. Passed by so-and-so in case number so-and-so, reference number so-and-so. Thereby declaring the petitioner to be a foreigner of 1971. Notice written within 4 weeks. Extra copies within 2 days, copy to the record, the following email address. The prayer for bail shall be considered on receipt of the tribunal's records. Next one. In the meantime, if the petitioner, namely Abbas Ali, alias Abbas Ali, is apprehended from a shall not be deported out of the country without order of the court. However, the petitioner shall cause production of a certified copy of the order before the superintendent of police order. Which place?
Bangladesh.
In the order. List also. Date. For me, 16th of March. 16th of March. Show me this data on 16th of March.
Obliged.
Upgraded item 22 for order implement of party.
Wait, please. My lord, there is a IA for implement of the new incumbent as respondent 1. As the earlier
Have you put the respondent to notice?
notice, my lord, the earlier incumbent has in the meantime, my lord, left the
We
office.
understand, but you see, contempt must be, somebody must not do something
Yes, Lord.
after receipt of notice.
Yes.
So how will the next person who is coming will know about this implementation? How is the contempt made out?
Contempt already, my lord,
No, you'll have to give them a notice.
I have given, my lord, page 16 annexer 2, my lord.
That is 925.
Yes, my lord.
It's to the new authority.
No, he was there, my lord, in the office.
No. It doesn't work like that.
The new incumbent
You
already
see,
got,
we both are in the same office,
my lord.
working for the same institution. Do you think a letter addressed to me will come to notice of my esteemed sister? Will my courtmaster know about it?
My lord.
No.
My instruction, my lord,
Contempt.
he already
Give
joined.
a notice, then come back. We'll
My lord.
permit you to bring it on record by way of an affidavit.
My lord, my lord.
Because this is a personal liability.
Yes. And so far, the other respondent, they are not appearing, my lord, despite,
We'll pass
No.
orders there. In this application, we are saying,
my lord, my lord.
had Mr. B. Barwal and counsel for the applicant. So this interlocutory application has been filed for including the new incumbent to the office as respondent number 5.
1, my lord.
Or respondent number 1.
Yes.
Okay, then number 1. So however, it is noticed that the party sought to be substituted as respondent number 1 has not been put to notice of compliance with the order dated 2/5/2025 passed by this court in WBC. Which one is yours?
My lord, WPC, read appeal, my lord.
So that order was passed in IA.
Yes. I am, my lord, 377, new one, my lord.
No. The disobedience is of order. Where is that order?
In the contempt, page 17, my lord.
So there's not notice for compliance of the order dated 11/6/2022.
11/6,
Passed in WA 61 of 2023.
my lord.
So accordingly, issuance of notice is deferred in this matter. Next, the petitioner, the applicant is given liberty to put the new incumbent to to notice of compliance of the order passed with this court. And thereafter bring the same on record by way of an
My lord, my lord.
additional affidavit along with the service report. This is the matter. Give a date after 4 weeks. We are deferring it.
Well,
We are not closing it, we are deferring it.
in the main case also, my lord, the service
In
is,
case,
in the main case, I pray your lordship. Lordship may allow to take dusty service, my lord. Service are pending for long, my lord.
but we permitted you dusty long back.
Thereafter, my lord, my husband died, my lord, and then my name is Sasul. So your lordship may allow, my lord. It's a financial payment, my lord, monetary. So I'm in distress.
Your substitution was allowed.
Yes.
But Mr. B. Barwal and counsel for the petitioner. So I just submitted that during the pendency of this contempt petition, the husband of the petitioner had expired. And he has been substituted as his legal representative. So, he submitted that the service by way of dusty could not be taken owing to these circumstances. Next, accordingly, the court is inclined to permit the petitioner to serve notice on the respondent numbers
2, 3, and 4, my lord.
by way of justice by running the process through the Ministry of the Court and upon service and affidavit of service, the service shall be filed prior to the next date of the sitting. Next, notice is made returnable on same day. 18/3/2026. Steps will be easy. 2 days. Next, the Learning Council for the petitioner is permitted to collect the postal receipt number from the registry and submit postal track report prior to the next date of the speak. Oh, sorry, it's not postal. Strike out the stick.
I'll file affidavit.
On service and bidding of the state will be prior to the next. Just correct that. Right? Notice not by registered post, no, just the. Yes.
Upgraded item 42 for orders. PIL Sumoto 1/2023.
Make legal office. Lord, in this case, this honorable court is monitoring this four-laning project of Silchar Harangagaon section by the National Highway and getting status. They have filed one status report today. And as per the status report, my lord, the physical progress is 90.12, and they assure at para 5 that two-laning connectivity to be completed in February 26, and entire project will be over by June 26. They have given some photographs also. Hmm?
Keep the matter then on first week of March.
Yes,
See the
sir.
progress.
Yes, that is better. With some updated status as on March.
Good. Mr. S.K. Das. Mr. Das, you're appearing as amicus curiae or as a.
No, as a standing counsel, my lord.
You're standing counsel for this.
It's a suo motu, my lord.
Mr. C. Barwal and CGC. Your CGC or?
Standing counsel, any Asia.
Yes. C. Barwal and standing counsel for NHAI. My respondent number 2 has brought on record an affidavit filed on behalf of respondent number 2. Today, bring to the notice of the progress of the four-laning.
Well,
Numerical problem. 4-alia work of Chatinga dash arrange HARANGAJAO section within bracket package AS-21 bracket close. Negative certain timelines in the progress of the project. There is in paragraph 5 of the said affidavit, it has been mentioned that the full two-lane connectivity is now targeted by February 2026. And the entire project, including ancillary works, is expected to be completed by June 2026, or subject to weather conditions. Next one. With the said target as indicated above. Court is inclined to adjourn the matter. Next one. The respondent shall produce the status report of the work. Next date of the sting, extra list. Again on 6/3/2026. No.
Highly obliged.
much obliged.
Upgraded item 43 for orders.
Delay condone, no objection. No, it is hello. This is Lordship, this is a application for the condonation of delay, Lordship, 126 days delay. On last date, Lordship, they were directed to file their objection, Lordship. Till date, I mean, they have not filed any.
We have no objection, my lord. Only, my lord, one part, my lord, paragraph 3, my lord. If they are agreed with this part, lordship, paragraph 3, my lord, guide.
Paragraph 3.
Yes, lordship. They are agreed by the, my lord, entire part, lordship.
That's been, WA. Paragraph 3 of the writ appeal.
No, my lord, of the IA. The IA, lordship. There is a two part, my lord, the entire was imposed, lordship. They are agreed by the entire part, lordship. Paragraph 3, lordship. Appeal order. 2602. 2602.
Ability list by name. Full for us, traffic. The matter not full to. Yes.
Paragraph 3, lordship, they are, if the, my lord, they are agreed with this part, lordship, payment of interest, lordship, we have no objection, lordship.
You not only want this IA to be allowed, you also want the writ appeal to be allowed.
No, no,
Then, he has no objection in condoning the delay, Lordship, that is one. No, no, he is making two submissions. Number one, he has no objection to this. He has
And
no
he states
objection. No objection to the prayer for interest also. So far as the second prayer is concerned, Lordship, in the learned single just was two directions. One for payment of. He's saying that he has no objection to that also. That means the interpretation must be allowed.
Lord. I have taken consent from the instruction from the client, lordship. They are not required. Only, my lord, 50% would be dispersed.
You want
Yeah, yeah.
50% only
Lordship,
the
interest per my lord bear or local. Because 50% is still hold lordship. 50% my lord compensation is still holding lordship.
Good. Mr. P. Nayak, London Additional Advocate General for the state, assisted by Ms. P. Bhagwan as the applicant. Also heard Mr. D. Gogoi, Learned Counsel appearing for the sole respondent. Next paragraph. The Learned Counsel for the respondent, who is the petitioner in WBC 6760 of 2023, has submitted that he has received specific instructions from the respondent that as per paragraph 3 of this interlocutory application, some of the Public Works Road Division has filed the connected appeal on the directions contained in the order dated 29/2024 in WPC 6760 of 2023 to pay 6% interest on the cost of on the 50% of land acquisition cost with 6% interest. Sorry, 6%, I said 6% interest on the land acquisition, balance land acquisition cost of 50%. In this regard, his instructions is to the effect that the applicant, sorry, the respondent does not object to the claim made in this interlocutory application for compatibility with the claim, but has no objection if the appeal, the connected unregistered appeal be allowed to the extent of directions to pay 6% interest on the balance 50% of the land acquisition cost. However, he has instructions to press for the early release of the balance 50% of the land acquisition cost. Correct?
Looks.
Next part. How much time to make payment?
Lordship, in fact, 50% payment we have already made. Remaining 50% lordship, the amount is ready with the department, I mean the deputy commissioner. But our only grievance is that in the meantime, lordship, some complaints were made and the vigilance inquiry is going on. Actions has also been taken against some of the departmental officers. Our only prayer is that till the completion of the investigation.
No, that investigation will take 10 years.
No, because
If you
allegations are very serious,
We
lordship.
understand.
Yes.
But you see, you must do something if he is conceding to that. You can't put him to a difficult situation where he withdraws his objection and does not get money.
That is one aspect, lordship. And secondly, lordship, the land, lordship, has not yet been handed over to the authority. They are holding the land.
For that, you are responsible.
But to my instruction, my lord, the proceeding by has been filed, lordship, to my instruction.
No, what do you want now? You want to withdraw, you want to concede to the appeal, or what do you want with the statement made by Additional Advocate General? What do you want?
We want 50%.
But that is not coming. It may take years and years.
This is lies on the, in the deputy commissioner office, my lord. There is a contempt case also pending, lordship.
We don't know about that,
Lordship.
but there will be serious consequences if we allow the writ appeal. You take a, what do you call, considered decision. We are not on, we will not examine what is the pros and cons of the order,
Yes,
but you will suffer that consequences. Take a considered decision. He has told you what is in his mind.
So that is my only, I mean, only till the completion of the investigation,
Then
lordship.
you.
If the ultimately it is found that the,
It's okay. Stop.
so this portion go then,
Be that-
lordship.
Be that as it may. As the limited prayer in this interlocutory application is to condone the delay. Next, the delay of how many days?
126 days.
126 days in filing the connected writ appeal stands condoned. Next, the registry shall list the connected writ petition and then list the same in the admission column. Not saying anything more.
Obliged, lord. Diplomas.
Upgraded item 44. Upgraded item 44.
I'm waiting for example number 4 and 5.
Item 46 for orders.
May I please, Lordship? Lordship, this I is for condonation of delay and 170 days delay in hearing appeal. Lordship. Apply Lordship.
Upgraded item 47 for orders.
Please, your lordship. Lordship, this IA is for to impeach the district commissioner Baksa and superintendent of police border Baksa lordship. Lordship. Lordship, I just want to point out one thing also. Lordship, there is some error from my part, Lordship, in prayer person also, page number 30. WPC number 50, I inadvertently written as 5037. It is 6961, Lordship. Some. Yes, Lordship. 961. It's 965. It is typographical error, Lordship. Yes, Lordship. Deeply over.
Upgraded item 48.
Paragraph 3 of my IA McCarthy is thing over. I have correctly mentioned the family trees in paragraph 2 of the petition. But invariably, my lord, in title page, my lord, in family tree, some mistake has been occurred. মাথা ভাঙা জিনিস সেইটো বস্তু title page. Yes, my lord. In paragraph 2, I have correctly mentioned. But inadvertently, my lord. Thing is that I could not check this, my lord. That is why my fault. Common বিষয় তারক করতে হ্যাঁ কত তারক কত বিষয় My lord, I am sorry, my lord. I am nowadays I am facing some difficulties. কিন্তু দেয়া নাই মই দি দিম In other, some cases I also facing some difficulties. Same difficulties I am facing some cases, my lord. I am, now I will thoroughly say. my lord. My dead sister is now leave, she is now no longer. He got the APP job, my lord. একদম বেয়া হৈ যায় এটা আকৌ এইবিলাকো বনাব লাগিব হয় নাই
কেইদিনমান ট্ৰেইনিং হ'ব
ছয়মাহ বুলি ট্ৰেইনিং হ'ব
এডমিনিষ্ট্ৰেটিভ ষ্টাফৰ লগত
নতুন জানিব লাগিব
Submitted that there is an inadvertent typographical error which is crept in the in one of the pre-pages of the writ petition where the family tree is provided. The description of the error is explained in paragraph 3 and 4 of this interlocutory application. So accordingly, the applicant, by filing this interlocutory application, has failed to allow the petitioner, the applicant, to correct the page disclosing family tree. Which having heard the learned standing counsel for the FP and bottom matters, they have made in this interlocutory application of the applicant shall, the applicant is allowed to file a fresh family tree providing the same to the AOJ FT section. The said officer on receipt of the amended copy of the family tree shall strike out the previous family trees and but retain it on record, and the amended copy shall be appended before the said page. Accordingly, this interlocutory, the same shall be done within a period of a week from the date of the order. That's the accordingly, this interlocutory application stands allow with 7 days time to carry out.
Hello.
For admission, upgraded item 28, 29, and 30.
My lord, item number 28, 29, and 30 are identical. Here we have challenged the order of the land secretary by which the land secretary has interfered with the order of recovery made against the petitioners, my lord, on account of huge transit losses, my lord, storage losses because of the negligence. Now, my lord, in item 28, there was an order by which, my lord, the Honorable Court earlier has directed me to list the other two items, item 29 and 30 together, because matters are identical. In item 29 was listed, the delay was condoned, this has come. But item 30 has come for the first time, my lord, because there is a delay. There are some defects in the if you appeal. So lordship may, all the delay, my lord, delay in all cases are same, in 28, 29, 30. So lordship may conclude the delay, my lord, list all the cases together, my lord.
Please, Mr. Gupta,
Yes.
no the delay.
Oh.
Because in there's an IA. 208. Was I think. Mr. Gupta deserves a thanks from you for not contesting.
And last this 28 and 29, those were condoned. Similar.
Those are condoned. Same delay.
That's why I don't want to protest.
We were directing him to offer you a thanks that you are declining.
Your lordship, in fact, now it is already delayed. We didn't file any contempt petition. It is 1 year past. 1 year
52
past.
days delay.
So we want to go by the merit of the case.
But Mr. P.K. Roy, Learned Senior Counsel, assisted by Mr. S. Chakravarti, Learned Counsel for the applicant. Also heard Mr. G.K. Gupta, Learned Counsel, who enters appearance for respondent number 1. For the sole respondent. Yes, ma'am. By filing this interrogatory application, the applicants are praying for condoning the delay of 52 days beyond the period of limitation is having the connected appeal. Next one. The Learned Counsel for the sole respondent has submitted that although he has objections to the period made, but as the delay has been condoned in the 2 connected matters, he is not seriously objecting to it. Next one. Ms. Zatati Kumar, having been informed at the bar that similar delay has been condoned in corrected WA 202 of 2025, WA 323 of 2025. Oh, sorry.
338.
No, not 27. It will be 338. WA 338 of 2025 and WA 297 of 2025. And in view of the submissions made by the Learned Counsel for the respondent, the period made in this application stands allowed. The explanation tendered for the delay is accepted as sufficient ground for condoning the delay of 52 days in filing the connected field. Accordingly, the said delay is hereby condoned. This application stands allowed in this paper. Next, the registry shall now list the connected unregistered appeal at the earliest and list the said appeal along with the connected WA 338 of 2025 and WA 297 of 2025 in the admission file. You want any fixed date?
Yes, kindly do that.
This has to be registered first, and then.
But since he comes from, it's
No,
not a regular
No, my lord.
counsel, we just asking him, when do you want?
After 19th March, any day.
Listed on 19/3/2026.
23.
Obliged.
Yes, go. 19/3. 19/3, my lord.
Obliged.
For admission, item 23.
Late Peter Lordship. Lordship, this is appeal filed by the State of Assam Education Department, Lordship. Lordship, this matter is led by Mr. N.J. Khatuniya, Lordship. But we sometime may be granted, Lordship. Today, Lordship, he had to leave court, Lordship, due to some reason, Lordship.
Lordship, can it be on 5th March? Fifth March, yes, madam. It both says represented on the day made by the council of the. The matter stands adjourned today. Next case is agreed to by both sides. This form 5/3/2026. Fifth March, fifth March.
Item 24 for admission.
May it please your Lordship. Lordship, in this matter, we have received an affidavit today, Lordship.
My lord, D.K. Sharma will appear, Lordship. D.K. Sharma is coming from this.
May-
May I please, I filed the affidavit today. To serve the credit to my lord.
Just now I have received my lord, just a minute. Next week, my lord, immediate, next week. No. 2 weeks time may be granted. 2 weeks time may be granted. If required, I'll file affidavit time. I'll file it. Come,
Mr. T.J. Mahanta, Senior Counsel, assisted by Ms. P. Sharma, Learned Counsel for the appellant, has submitted that he has sometime back been served with a copy of affidavit filed by the state respondents. Accordingly, he waits for, he's granted 2 weeks time to respond, go through the same and respond. If so advised. Next, Mr. D. Sharma, Learned Additional Senior Committee Advocate.
I don't just know.
Is present. Next.
So interim order pass.
Not today, rest on.
Any, my lord. 2 weeks. Okay.
We did after 2 weeks.
An interim order pass.
9th of March.
My lord, interim order continue.
Interim order passed to next and extended till next week.
Deeply.
That was effective.
My lord. Yes, my lord. Yes. Last 1.5 year they are sitting now, my lord. Anyway.
But we have to appreciate Mr. Sharma.
Yes, yes, my lord, definitely.
Oh, well, right.
Very.
Because of your lordship indulgence, my lord, that was
Deeply.
obliged me.
Admission, item 25.
Lordships, in this matter, today we have received affidavit filed by the respondent of 5, Lordship. So that affidavit may not be on record.
Pardon me, please repeat again.
Lordship, today we have received one affidavit filed by the respondent number 5. I think that affidavit is not on record.
Yeah, Abbas. Respondent number 5 submits that he has received a copy of affidavit. Filed by respondent number,
5 loss.
you are for,
I am for petitioner loss.
for the petitioner submit. He's in the set of copy of affidavit in resolution filed by respondent number 5. He submit that the same is not in the court. Accordingly, let us say 21.
Let's say after 1 week. Quarter.
February. Forest on the Lordship, in Forest Department is less side also. In last order also there that their name may be reflected. I think the cause list Department of Forest is not showing lordship. So
25.
in last order was also it was recorded. With Department of Forest has to be shown in the cause list.
This is an effect in name of SC. Environment forest, see the matter next.
Deep level. 27 March.
Item 27.
Right.
Made please, your lordship.
Yes.
No notice was issued, my lord. It's a appeal, my lord. My appointment was, my lord, I appointed as a compound. I was selected as a compound. That selection was challenged before this honorable court and writ petition was allowed. Against that order, my lord.
Amended the memo of appeal.
My lord?
Have you amended the memo of appeal?
No, I have not amended the memo, my lord.
No, but there's a judicial order.
My lord.
Look at this.
No.
Look. There was a submission made that the writ appeal is required to be amended. You said that you will examine and tell us.
My lord. 17/10/2025.
You don't know, since that was the order.
My lord, yes.
Go through the file.
On the honorable citizen has realized, my lord, that affidavit has not been up.
No, we are not aware.
No, my lord.
Because the order is not.
No, my lord. And that day when the admission come, my lord, it will come for admission. He says that, my lord, some documents are not annexed. Some documents. So, my lord, that was his submission. So then this order was part. My lord, I don't think that it is required, my lord. If required, my lord, I will supply the document.
Not required.
My lord,
You said that it's not required.
Not required, my lord. Because he say, what is his contention, my lord? His contention is that some of the document was not annexed. Those are a document, his document, my lord. Because, my lord, what happened? He was the lead petitioner. He was the lead petitioner, and some documents are, my lord, at that point of time, my lord, it is not eligible, my lord. That's why we annexed the affidavit. But you know, what are they have, no, now if required, I will give it, because now I collect it and make it type copy, my lord. Because these are the documents he placed before his court, my lord, in fact, it's given to me. What are they? Memo of appeal, no remark. Serial number 8, contempt one is not there. Petitioner number W with annex, and these are the annex additional.
Both of us, it will be out of context. You have to tell us what is happening. In fact,
My lord.
you cannot go through the record.
My lord.
What has happened here? In this writ appeal, there are documents which are missing.
No, my lord, not missing.
Then
He says that I have annexed the affidavit, filed in the before the learned single judge without annexes.
okay.
That is the case, my lord. So these are the affidavit, my lord, filed by him, my lord. Some replies, some miscase, but that now, my lord, record is there, my lord. And if required, I will deem. But it is not required to amend the petition, my lord. Not required to amend the memo of appeal.
No, but the document has to be given to us because we have not gone through the records. If the documents are relevant, then you have to annex those documents.
My lord.
It has to be a part of the writ appeal.
Then all right, my lord, your lordship, kindly give me some time, then I will, my lord.
You say that only the documents which were there in the affidavits are not enclosed. Only that much.
Yes, my lord, he has given for example, my lord.
My lord, in the info judgment, my lord, paragraph 12, my lord, the honorable single judge relied upon additional affidavit, annexure 1 of the additional affidavit. That affidavit has not been here, my lord. And the crux of the matter starts there, my lord.
Additional affidavit?
Yes.
See, all right, my lord, let him pinpointly, my lord, he is given, then my lord, I will next, my lord.
But paragraph 12 of the info judgment, my lord. The honorable single judge relied upon, my lord, additional affidavit, annexure 1 of the additional affidavit, which was filed by me.
Additional affidavit filed by writ petitioner.
Writ petitioner. And that.
No, just a moment. Let us examine those things. That is at page 132. Correct. The additional affidavit is on page 132.
My lord, 143, my lord. My lord, kindly see the info judgment, my lord, 143.
No, please, you see, we are looking at your documents one by one.
Document.
Yes, my
You
lord.
referred to additional affidavit.
Yes.
Is that affidavit at page 132?
That. No, my lord, that affidavit is not here in this appeal.
Then what is there at 132? What is this?
132.
What is this?
My lord, this affidavit has been filed, my lord, by me, my lord, because, my lord, they have
Please give us the description. If this is not the document, this is not the document. 132 is not the document.
Yeah, this is a document also, my lord. This.
Please don't confuse us. We are already confused ourselves. You say a document has not been there.
Yes.
Now, which is that additional affidavit? It is not here next year.
It's not annexed. It even entire affidavit has not been.
Is the affidavit there?
That is your document.
In writ petition, my lord.
Page 132 is some other affidavit.
Some other.
You have a copy, just show it to us.
All right, I'll collect him.
Appellant, expert. Mr. Spiroid, for respondent by 8 has submitted that And additional affidavit.
Your document.
Filed by the writ petitioner. Within bracket, respond number 8. Number about 16/8/2022. Along with its enclosures are not part of the memo of appeal. Just say all documents are not a part of the memo of appeal. That is one. Second,
Second, my
prepare a
lord,
list and give it to us.
my lord, I have given already, given, I have already given a list.
Make this a part of our. Don't highlight. No. It should not be bold.
My lord, this,
This one.
yes, sir.
Just forget of it.
Prepare করছিলাম আমি তো, ঠিক আছে। ফাইল আমাকে তুললে হবে শুধু।
One, two, three, 4, 5, 6 items. Next para, moreover, comment is submitted that the contents of paragraph 8 of the memo of appeal are not the contentions of the respondent number 8.
That, my lord, regarding 8, my lord, even my lord, you will also believe that it is not required because it
No,
is
we
in
are
the.
not doing anything. You will have, you tell us, we'll do it.
No, my lord, what happened, my lord, that is, my lord, in review petition, we have.
We don't know about that. If you tell us that delete this para 8, we'll do it.
No, all right, those annex are his documents, that those are his document, it was not illegible, that's why I take time to collect it. But those I will give in. But so far is that my your lordship kindly see that is in a review petition, which is, my lord, I even not required to, my lord, annex, even then I am annex, my lord. That is, my lord, it is not the, it will not help in the main case, my lord.
We are stating about his contention.
My lord,
What
sorry.
is your response? We are not looking
My
at
lord.
that. The learned instructing counsel for the appellant shall go through the same and
My lord.
bring the missing documents on record. Next para. Matters from adjourned today, list on.
After 3 weeks, because already I am out of service. He is enjoying
It's
my.
okay. When do you want?
It was not a, he was not appointed, I have been appointed.
Oh, whatever either you do the hearing or you take an adjournment. If you want to do the hearing, do it.
Yes, yes. My
You're
lord,
not shying away from the hearing.
within 2 weeks, my lord, I can do it.
This is the date.
That-
The current
that's the
date.
16.
March.
5-6 months more than I needed.
Or 9 minor, 9 months.
9th,
9 months.
9/3/2026. Take back your document.
Develop.
We'll have to raise this things. Before I summon, I have a small prior matter. Item number 32 and 33, my lord, it is relating to my provincialization has been withdrawn, my lord. And by virtue of the order of the honorable single judge that I put into challenge, my lord. So can it be taken up on Wednesday at 2 o'clock, my lord?
No, we are not allowing that because this is normally a roster of Honorable the Chief Justice.
My lord.
We are just, whatever we can't take it up, we leave it. You make a mention before they set bench. Because we are not listing the matters in the.
Your lordship, can it be on 25th?
No, we are not fixing
Oh,
any.
my lord, sorry. Yes.
You,
I'll make.
you make a mention before the.
Yes, before the appropriate.
Honorable the Chief Justice.
My lord, I have a prayer in item 49, my lord. This is a part hard matter, my lord. It's a hearing matter, my lord. My prayer before your lordship is that, my lord, if it is possible, my lord, I have come with some of the citations, my lord. This will take some time, my lord. If it's possible, my lord, lordship will be pleased to, my lord, list it up just after, my lord, 20th of March, my lord, if possible. My lord.
You have some difficulties.
Yes.
Okay, you have positive time. Both sides are represented.
Item 49.
49. Both sides are represented. Positive time matter cannot be taken up. Should not be taken up. Next, Mr. Z. Ahmad, London Council for the petitioner, something that he has some difficulties. Argue the matter before 20 March 2020.
28 March.
28. 20.
28 is a holiday, my lord.
Oh, April 27, 20.
26 is all right, my lord. It's a hearing day, 26.
So till when you can't appear?
My lord, till, my lord, within 20th of my lord, March. My lord.
Till 23. Accordingly, list the matter on 24/3/2020.
My lord, my lord.
24/6.
Yes, I'm deeply.
Lordship, regarding item 41 of today's list, Your Lordship, it pertains to disconnection of electric supply. What happened in this matter is that this Honorable Justice A.D. Chaudhary cannot take up the matter. And that is why on last occasion we have mentioned before the friends, and accordingly it was ordered to be listed today. But since it didn't reach today, so may I pray that it may come up tomorrow, Your Lordship. There is urgency because it pertains to the disconnection of electric supply to my factory, Your Lordship.
Positive time matter could not be taken up today. So, submitted by the counsel for the appellant that the industry of the appellant is without any electricity.
No, as of now, there is electricity, but we have got a letter that the electricity will be disconnected.
The respondent said certain disruption of electricity to the industry of the appellant. Expert will be just expressed list on week tomorrow 17. Okay.
Obliged.
Lordship, with respect to item 52 of today's list, there is some urgency, Lordship. It pertains to a challenge to dismissal from service.
52, you'll have to make a mention before Honorable the Chief Justice. We are just leaving it untouched.
Okay, obliged.
If it goes left over, make a mention.
Obliged.